something and gets the full economic value of that bargain. The government asks this court to chart a different path. It argues that a property interest is harmed in a property fraud case whenever somebody gives money pursuant to a fraudulent a misrepresentation. That would cause three major problems. First, it would flout decades of this court's precedent. Indeed, it would allow prosecutions just like McNally, Simonelli, the hypothetical in Skilling, and others that the court has said are beyond the reach of the fraud statutes. Second, the theory is incompatible with the historical origins of fraud. In an 1893 case that's representative of the time, the Kansas Supreme Court said, even though money is obtained by misrepresentation, if no injury occurs, no crime is committed. That sentence is incomprehensible under the rule the government argues today, which says that anytime there's misrepresentation that procures money, that itself is injury. And thirdly, and perhaps most decisively, the government's theory knows no bounds. Every day across the country, people use white lies, puffery, and other fraudulent promises to induce people to enter into transactions. But if there's no harm that occurs in those transactions, there is no fraud. That's what that's what this court has said time and again in this court's cases, as the government has tried to concoct one theory after the other to work around that. Such misrepresentations might be a civil violation, they might be a tort violation, a contract violation, they might even be a low-level criminal violation, but the one thing this court has said time and again is that they do not constitute property fraud, because property fraud requires harm to a property interest, and no such harm occurs in a case like this. I would welcome the court's questions.
Beginning with the facts in this case, give me an example of what would constitute fraud?
Well, it would have constituted fraud if we had delivered bridge painting and repair services worth less than we promised. So if we hadn't painted the full bridge, if we'd used less products of a higher quality to deliver the project, that sort of thing, Justice Thomas. So that would be a violation. But here, you don't have anything like that. The government's theory, and this is at JA 96, was that the promise here was non-financial in nature. And what the government argued to the jury is, this case is not about dollars and cents. This case is about PennDOT's programmatic interests. And I think in the court's terms, that means this case is about regulatory interest. And that's what the court taught in Kelly and other cases, that mere regulatory interests do not supply the basis for property.
I'm sorry, Counselor. Let's assume the example that I contract to have a certified plumber fix whatever. All right? And I don't use a certified plumber, I just use a handyman. But the toilet is fixed. Under your theory, even if I didn't use a certified plumber because the toilet was fixed, I got value under the contract?
No, I don't think so, Justice Sotomayor. There, the fraud would be promising services that were more valuable. Now, the certified plumber presumably would charge more per hour.
But I don't understand what the difference between that and this case is. The services the government contracted for was to have a particular type of vendor sell me something.
But well, that's not precisely right. I think what the contract here was with Alpha Construction, and Alpha Construction then got to choose its own subsidiaries. Now,
but of
the
a
government
particular,
had an interest,
but someone who was certified,
right? So
someone who had a certain composition.
But I think that so I think you're right about the word certified in a sense. But the certification in your plumber hypothetical deals with somebody who has greater expertise or experience and therefore charges more.
So what
that's how I
difference does it
understand
make it if I want someone of a particular quality? When I hire a portrait artist, I want that person. I can get a portrait artist from anybody. Here, the government wanted a particular person to provide the service. That's unique, what they wanted.
I don't think it's unique in the sense that some of the cases talk about uniqueness, and I'm happy to get to that. But I think, Justice Sotomayor, the key question would be, was the thing that was promised and not delivered more valuable in the marketplace than the thing that was delivered?
I always thought the key question was, that term material to the transaction? Did I get what I paid for?
So there is a materiality requirement, yes, at the end of the statute, which I don't think that's exactly the way materiality is analyzed. In Nieder, the court said what the materiality test is, was it important to inducing the person to enter into the transaction? That's what materiality is. What this case is about here is whether you need to have a harm to a property interest. And what our position is where you get full economic value of the exchange. And that means not just the end product.
Where do you get
Maybe I could give you.
What about, Mr. Fisher, what about this uniqueness thing? Let me kind of bring you back. You mentioned to Justice Sotomayor that uniqueness matters. What about your Grover Cleveland example? The one about if you contract for a painting of your grandfather and you wind up with one, say, of Grover Cleveland. That's not exactly what you wanted, but let's say it's of equal value. So you've suffered no economic loss. So why, or would that qualify as an injury?
So I think that's the one hard case in the corner of the law. So can I just state the general rule and then go to the exception? So the general rule would be frustration of subjective economic interests. If they're subjective, is not enough to trigger the property fraud statutes. Now, I think the one possible exception that might have a foothold in the case law is this uniqueness consideration. And I think the reason why, whether it's a painting, a horse, maybe it's a particular piece of land, is that when you deal with something that is truly one of a kind, economic value there is so subjective in nature that it really doesn't necessarily work so well to say the other thing was of equal value.
How do you know if it's so subjective?
When you have a one-of-a-kind item, I think the grandfather portrait or a piece of land is often talked about as being unique to another piece of land. Like I wanted that house on that plot of land as opposed to another. That's a special problem in the law, and you find it even beyond the property statutes. Things like specific performance doctrine and other things bleed into that. But when you don't have uniqueness, and this does get me back.
Well, Mr. Fisher, let me just pause you there. I'm sorry to interrupt, but specific performance, you've referenced that concept. And yes, and you admit sometimes when I contract for that horse or that painting, I want that thing, even if you provide me with something of equal value. The injury is satisfied there in traditional fraud law. Why? I think we all agree on that. Is that right?
Well, I think you don't have to decide that in this case, and I think
but we agree
treatises generally say that.
That is generally true under common law fraud doctrine, right? So if we accept that, why isn't that this case, I think, is where I struggle, where the contract specifically says we want DBEs. Now, maybe you should have them, maybe you shouldn't have them, but that was an essential part of the contract and what was sought, and it wasn't provided. So why isn't that like the horse or the painting or any other specific performance case?
Well, I think for the granular example under this contract, remember, the contract itself didn't even, strictly speaking, require DBE subcontractors. It required our clients to make best efforts to procure certain supplies with the income they receive from the contract from DBEs. So even under this contract, it's not so much an insistence that you use DBEs in the way you would have in the painting or the horse. But even more generally, I think there's a distinction that runs through the law between something that is truly one of a kind and something that is of a class. And if you deal with something that is of a class—
horses are of a class, properties of a class, paintings are of a class. It turns on what was contracted for and whether it was specifically sought, a specific item, whether unique or not, whether that was sought.
Well, Justice Gorsuch, I think—
I want the horse named Charlie. You know, there are 15 other horses in the corral that are every bit as good, but I want that one.
Well, I think that if you want to follow the common law did distinguish that. And of course, even if every answer I give you today isn't satisfying, I would still tell you that what the court has held in Nieder and other cases is these statutes incorporate the common law, and the common law did draw this line. And so I'll do my best to explain it.
All right, one more question. I take your point that there's got to be an injury requirement. There certainly was a common law fraud, but the government says that's not necessary. Materiality will do all the work. What's the problem with that?
Well, there's two problems. One is that's just not the way the common law did it. The injury requirement is tied to specific harm to property interest.
Now,
materiality is much broader than just harm to a property interest. So you'd have to mangle the materiality requirement to do the work that the traditional property fraud harm requirement does. Now, the government, I think, recognizes that when it looks at the materiality requirement in Nieder and says, oh gosh, this is crazy broad. This doesn't do the work we need it to do. So they invent this essence of the bargain test. But even that, for all the reasons we say in our brief, doesn't do the same work that the traditional requirement does.
Mr. Fisher, I guess I'm struggling with the idea that there has to be a harm requirement in this context, because I don't see it in the statute. And this is a criminal action. This is a criminal case. I would think that Congress was focusing on the harms that arise from the wrongful conduct of the defendant. It names certain elements. These are things that you are prohibited from doing, or else you will incur criminal liability. And many of the common law cases that you point to are in the civil context, where you would need a harm, obviously, in order to sustain a claim for damages. So can you help me understand where you're coming from with the need to have some sort of other harm in this context?
Sure. Let me answer first in terms of the statute itself and then the common law. In terms of the statute itself, the easiest way to understand the case before you today is it's about what the meaning of defraud is. So this is a textual argument we're making about the meaning of defraud, and I'm just making the classic argument that the word brings the old soil with it. And so
But it depends on what the old soil is. And my other
so let's
part,
get to that.
Yes,
so,
thank you.
So that's where it is in the statute. So then the old soil, as the court itself said in Nieder, both involves civil private fraud like deceit and criminal fraud, false pretenses. So if you look at either of those things, you find the injury requirement. We cite treatise after treatise, case after case. The reason why we look to civil law, if that's part of what's hanging you up, is because historically criminal fraud dealt just with the government. And so civil fraud gets
Yes,
you,
but what's
gets you private injury.
What's hanging me up is kind of the facts of this case. Because to the extent that you're talking about what you appear to concede is a material term in an agreement, which is PennDOT says we want contractors who are engaged with subcontractors who qualify as DBEs. And you have these folks, your clients, understanding the materiality of this so much so that they concoct a scheme whereby they misrepresent the extent to which they really are relying on such DBE subcontractors. I don't understand why, given our just classic understanding of fraud being deceit with the object of obtaining money or property, why this doesn't count. You've switched it to, I noted from your introduction that you said a scheme to defraud is a scheme to harm a traditional property interest. I had understood it to be a scheme to obtain a traditional property interest, that all of those cases that you cite, the Simonellis, et cetera,
Yeah.
were about the person's intent to obtain money or property. And I think that is what's going on here. So why don't we just have the sort of classic fraudulent scheme to obtain property under false pretenses in this way?
So I think there was a lot there. Let me try to break it down into two parts. First, let me explain why it's not classic fraud, and then explain the implications if you were to say it's within the statute. So first, the reason why it's not classic fraud is classic fraud does require more than simply obtaining money by misrepresentation. Look at the Kansas Supreme Court's decision in Palmer. Look at the Arkansas Supreme Court's decision in Morgan. Those are both criminal cases, even if you want to stick with just criminal cases.
What about this
Justice
court? Have we ever, we've never interpreted the
This
wire
court-
fraud statute?
Of course you have. This court, time and again from its earliest days, said this statute involves harm to property. It involves loss to property. Those are the words this court has used both near the enactment of the statute and more recently in cases like Kelly and in Skilling, where the court said the way the statute works is that the defendant's
It's not about the
loss
scheme.
mirrors
It's not
the
about
gain.
the scheme. I'd understood that scheme has something to do with it.
Scheme does have something to do with it. You have to scheme to obtain the property.
Correct. And why isn't that here?
And that, yes, and because you have to scheme to harm the property as well. There has to be harm that follows. And so what the Kansas Supreme Court said in Palmer was there might be lots of deceit and untoward behavior out there in the world. In fact, that's the problem. It's everywhere. But to cabin criminal fraud in any meaningful way, you have to cabin it to where there's actually injury that follows. And so the exact argument you make
And it's
was
not
made
enough,
in
the wrongfulness of the defendant's behavior in a criminal context is not injury, you're saying, for the purpose
Correct.
of the criminal law.
Exactly. That's what Palmer says. That's what the Arkansas Supreme Court said in Morgan. So let me give you those couple of examples, Justice Jackson. In Palmer, what happened is the defendant went in and lied about how his business worked and what his business was for purposes of getting a loan. It induced the person to give the loan. But he put up proper collateral, and the Kansas Supreme Court said even though he lied to obtain money, not fraud. In the Arkansas Supreme Court case in Palmer, the defendant lied to the person wanting a hotel room and said, your friend stayed here recently.
Right,
and
those
so
are
you'll
all
like the room."
fraudulent inducement in the sense that the lie is not about the service.
Yeah.
It's not about, Justice Sotomayor brings up the example. This is a material term of the contract. The service that I want is a plumber who is certified, or a plumber who is a DBE, for example, bringing it closer to this case.
Yeah.
I don't understand why, when someone schemes to get around that term, not only breaches it, but also then lies about having fulfilled it, that doesn't qualify as a material misrepresentation that triggers this statute.
It could be material, but there's no economic harm or other property harm, and that's what's
What do you do
missing.
about the
If you
donation
take-
cases? What do you do? So fine. What do you do about charity? All right. The government raises this in their brief. I am, wanting to donate my money to a cancer charity, and I'm not receiving anything in return. I am giving the money away. When it turns out that the charity to which I donate has concocted an entire scheme to get me to give them the money, and they're not actually giving it to cancer patients, they have nothing to do with that, but they made all this up, and I give them the money, does that qualify for wire fraud in your view? There was no harm to me economically.
Sure there was. You gave money and you got nothing in exchange. This case
I
is
got
totally
something
different.
Well, I did get something in exchange, didn't I?
No, I don't think so. I think it's not very different than stealing. I mean, they just lied to you to obtain your money, just like they took it against your will. Here, there's an economic exchange. And Justice Jackson, it cannot be that every material provision of this 1,100-page contract would give rise to a property fraud prosecution. Only the terms that deal with economic or other property interests can give rise, because otherwise this theory knows no bounds. There are all kinds of promises, even if you want to keep it more cabined than the examples I'm giving you. Look at the Second Circuit's more recent decision in Regent Supply, where there's aggressive salesmanship techniques. The person says things like, your friend referred you to me. He says things like, there's only so many left in our warehouse. All these things that might induce somebody to buy a product or take on a service that don't have any value. Just taking a babysitter who there's two babysitters on the block, and one says, I'm going to use the money I earn to take my sick brother out to dinner next week. And so that's why they pick babysitter A versus babysitter B.
What about the family?
That's no different than
What
this
about the
case.
family that says, it's very important to me to have a Christian babysitter. We are devout. We want this. This is a characteristic that we're telling everybody this is what we're looking for. And someone comes and they purport to have this characteristic, but they don't, ultimately.
I think that's egregious behavior, but it's not property fraud. If the babysitter is otherwise fully qualified and performs the services. Now, there may well be a very serious civil suit. If you're dealing with the government in that kind of a situation, there can be a 1001 prosecution or maybe a 371 charge. So I'm not saying these things are okay, and I'm not saying the law doesn't provide a remedy. But what I am saying is that this is an age-old problem when it comes to fraud. Justice Story talked about it in his treatise. The Kansas Supreme Court talks about it in the Palmer case I've talked about, which is it is tempting to use criminal fraud to cover lots of forms of dishonesty or deceit. But the problem is you end up in a world where everything ends up being covered.
Mr. Fisher,
and so you have to draw a line.
I don't really understand the limits of your argument. So a party enters into a contract to get a particular good or service, and the party does not get the particular good or service that the party wants, but it gets something that's worth even more. Would you say that whenever that is the situation, there is no fraud?
I think the answer is yes, with the possible proviso of the unique item situation. But I think that, Justice Alito, kind of brings the government's theory to light in an odd way, which is imagine somebody wants a Ford and he gets delivered a Ferrari. and the government puts that person on the stand and says, gosh, it's like I hit the lottery. I got something 10 times more valuable than the thing I wanted to buy. Under the government's theory, that is property fraud. And that seems like a very odd result. And the thing is, there may be other situations where the thing you get is less valuable, and that's a classic situation.
I don't know
for fraud.
whether that's a very odd result. Suppose I have 2 trees in my yard. One is an oak, and one's a weeping willow. And I hate the oak because I'm tired of raking up the acorns. So I hire somebody to cut down the oak tree. And when I come home from work that night, the oak tree is still standing, but the weeping willow is gone. And he says, well, the oak is a healthy tree. It's got deep roots. The willow has shallow roots, and any storm could knock it over, and it could damage the house. Have I not been defrauded there? I didn't get what I wanted.
I think you might have been harmed there with the property of your tree being taken away. I mean, I think I think that's just an odd hypothetical, but with a normal service,
Well,
I
could give you 1 million of them. I hire somebody to paint the dining room of my house. And when I come back, the dining room has not been painted, but the living room has been painted. And the living room is bigger. And he says, look, I gave you a bargain, same price, I painted more. Plus, the living room really needed it more than the dining room.
I think we're still in this difficult situation of there's actually, your home is your property, and so some of the things that are happening to your property, but I think what you're trying to get at, Justice
Suppose you enter into
Alito.
a contract and you think you're going to you pay for gold bars that are worth $1 million, and instead you get lots of coal that's worth $1 million. Have you been defrauded?
So I don't think you've been defrauded under the property fraud statutes. You may have been defrauded if you were dealing with the government under Section 371, which doesn't have an injury requirement.
But you really
It may
have
be-
totally not gotten what you wanted. I mean, you're creating a world where because I have $1 worth of loss, it falls within the statute. But rather than $1 worth of loss, I've gotten something that I have no use for, that I never wanted, that I made clear I never wanted or had use for. It happens to be the same in a marketplace out there, but it sure isn't the same for me. I think that this is a terrible deal that I've gotten. And it's not the one that I signed up for.
So let me say a few important things about that. I mean, my core submission is that subjective disappointment when you get something different is not enough. But here's a couple of things you could say about that. One is, that is not this case. Here in the Third Circuit's own understanding.
It goes directly to your theory. Your theory is $1 worth of loss makes all the difference, as opposed to the government's theory is, were you defrauded out of something that you thought you were going to get?
Right. So I understand, Justice Kagan, that every legal rule is going to seem perhaps arbitrary at the margins. So if you want to tell me $1 or a penny, I have to give you the answer yes, because that is loss. On the other hand, the problem with the government's theory, which is subjectively I didn't get what I want, is it has no limitations. So the coal versus the gold, what if they wanted gold from somebody who was producing it within local county and not from outside county lines? What if it was, I want some coal from somebody who's a friend of the family? All those things you could characterize with wordplay as the same argument. I didn't get what I wanted. And the other thing about those hypotheticals, Justice Kagan, I understand believe me, I've been through the moots. They're very hard, and they seem odd. But it doesn't happen in the real world. The real frauds in the real world are when somebody's giving you something less valuable. That's the whole point of an ordinary property fraud. Mistakes happen in terms of the wrong item being delivered every day in the marketplace, but we don't ask ourselves whether there should be a fraud prosecution. We ask ourselves whether we can take it back to Amazon. I mean, these things happen, but unless there's actual less value involved in the alternative item, or the parties have agreed to some premium for one thing versus the other, there's not really any reason for somebody to come up with a scheme to give somebody coal, instead of gold. If the coal's worth the same amount, you could just sell it to somebody else who wants coal.
Mr. Fisher, is the government's theory really unbounded? They don't quite advocate for a materiality requirement, but let's say materiality could be a limiting principle. Why doesn't that work? Then that means that every white lie is not going to count as something that would fraudulently induce you to enter into a contract.
I guess white lie, you're right, Justice Barrett, but the test for materiality in the restatement, which is what the court looks to in Nieder, is any important fact that induces somebody to enter into the transaction. And the babysitter hypothetical I gave you, imagine somebody selling their house because one couple says they want to raise a family and somebody else says they don't, and I want to support the block. There are numerous, and we cite so many in our brief, examples where that ordinary materiality requirement is met, which is, if I can just add one thing, which is why I think the government tries to monkey with the materiality requirement and ratchet it up. But for all the reasons we give in our brief, that just doesn't work either and creates more problems.
Thank you, counsel. Does it matter at all to the limits of your theory whether or not there's an alternative avenue of relief, or is that irrelevant?
I don't think strictly speaking it matters, but I think in almost all the difficult hypotheticals where we'd feel like somebody has been harmed or injured in a subjective way or just cheated, there'd be alternative remedies. So there's tort, contract, and that's what the court has said time and again in cases like Skilling and Kelly and so many others. Look, the court should construe these statutes not to run roughshod over state contract and tort law, not to mention other remedies that are available.
Do you recognize the availability of an alternative remedy in this case?
Well, the government prosecuted these same clients under Section 1001, and so I think if they prove the elements of that offense, yes, they can procure a conviction.
Thank you. Justice Thomas?
In your research, have you found that there have been quite a few of these fraud cases in this context brought by the government?
What do you mean by this context? Do you mean DBEs?
Yes.
I think there are some. I don't think they're tremendously frequent, but there are others that are out there.
So what distinguishes this case from the others? It would seem that with that many contracts, the broad use or wide use of these contracts, that you would have a history of some fraud litigation.
Well, as I said, I think there are occasional breaches of these promises that give rise to prosecutions. I think the thing that distinguishes these from legitimate prosecutions, Justice Thomas, is that there's no economic harm here. Remember, JA96, the prosecutor said, this is a non-financial interest about our program. So just imagine all, if I could say
well, let me
yeah.
give you a different version, just to be clear about what your argument is. Let's say that a company says that we will build your patio for a certain price, but every month we will give a patio to a veteran. Mm-hmm. And you make a decision to allow them to build your patio with the understanding that they contribute every quarter or every month a patio to a veteran. And then you find out afterwards that they did not provide patios to veterans. Is that fraud?
It's not property fraud, Justice Thomas, and the reason why is because the homeowners would not have been defrauded in their property interest. They wouldn't have suffered any property or economic loss in that transaction. So it's no different, Justice Thomas, that if somebody said, my mother is sick and having cancer treatments, and I'm going to use these proceeds to help pay for those doctor's bills.
Is there any amount of deceit that would amount to fraud if there's no property loss involved?
No, and this is exactly the problem Justice Story talked about. It's exactly the problem the Kansas Supreme Court talks about in Palmer, is there can be extravagant lies and whopping tales that are told, and so it can be tempting to want to punish that person, but unless there's harm to the property interests involved, there's no case. Let me just make clear, this is an 1,100-page contract, and what the court has said time and again is mere regulatory interests cannot give rise to a property fraud prosecution. If the government is right, every regulatory interest written into a contract, imagine during COVID, somebody said, we want you to perform this project, but you have to use masks when they're indoors. It's a very important governmental interest right now these days, and the person didn't wear a mask indoors. That would give rise to a property fraud prosecution punishable by 20 years in prison, even though it was just a regulatory violation.
Justice Sotomayor? Justice Kagan?
Suppose the government has a program and it sets aside money for veterans, and somebody comes in and creates a whole set of lies to prove that he's a veteran, but he's not a veteran. Is that fraud?
I think it is under the exchange I had with Justice Jackson, which is if you just take something for nothing, that's just stealing. Now here, what the court is dealing with here is an exchange.
Suppose that instead of setting up a benefits program of that kind, there's a contracting program that says, we want to give these contracts of a particular kind to veterans, and somebody comes in and delivers the same set of lies in order now not to get just the assistance check, but to get the contract. Is that fraud too?
So my answer there, and that was where I would draw the line, would be no if the person performs the full economic value of what was wanted in that project. And that's what Section 370.
What's
that's
the
what
difference,
Section
Mr.
370.
Fisher? You're going to tell me that one is fraud if, there's a benefits program for veterans, but the other is not fraud if there's a contracting program for veterans? Why should that matter?
Because the common law made clear that there has to be harm to a property interest, and merely giving money and getting full economic value back is not harm to a property interest. And I think, Justice Kagan, that is very serious.
Even though this whole program, if I may, has been set up in order to provide contracts to veterans.
I think that's
not in order to get the paint job of your dreams.
That's right, and let me say two things. One is, I think that's precisely why you have Section 371, which is defrauding the government in its programs and frustrating its programs is a crime punishable with 5 years in prison. That is a classic Section 371 case, and that's probably why we have that statute, because the property fraud statutes, the mail fraud statute and the wire fraud statute don't cover that conduct as a matter of common law understanding of fraud.
Justice Gorsuch?
Mr. Fisher, it seems to me the tricky part of your case is that a common law an injury could be if I didn't get a particular thing, the horse, even if I got something else of value. The tricky part for the government, though, is if there is no injury requirement, then every material misrepresentation that results in no injury to anyone becomes a federal crime. And I want you to talk a little bit about that, your babysitter hypothetical, and the essence of the bargain, which language they try to put into the materiality requirement, which just seems to me benefit of the bargain, which seems to me an argument really that there is injury here because we contracted for a specific horse, a specific thing. So what am I missing there?
The injury needs to be to your property interest. So when you're dealing with money and you get full economic value back, at least as a general rule, there's no harm to that property interest. Now, we can set aside the unique item situation, and maybe I hope this is responsive.
I want you to focus on the materiality argument that the government's pressing and how it may or may not smuggle in a benefit of the bargain injury requirement.
Well, if I'm being honest, I don't quite know what the government's essence of the bargain test means. If you take it to mean what the restatement means, it's much more than materiality, because what the restatement says is there are lots of things that are important inducements to enter into a transaction, and the restatement is clear. Those do not necessarily go to the essence. So the only thing that goes to the essence under the restatement is something that would destroy the value of the entire transaction. Applying that to this case, this whole transaction was about painting bridges and doing repairs with quality workmanship. How we used our proceeds doesn't remotely go to the essence of the bargain. So I don't quite know what the government is arguing when it talks about essence of the bargain. And I think, Justice Gorsuch, I hope it's responsive to your question. Let me just say one other thing, which is I understand this little corner of uniqueness is tricky, but the government has this much bigger problem. And what the court's cases teach time and again is the federalism concerns and the overcriminalization concerns make this even more than an ordinary lenity situation. These statutes, as the court did in Skilling, they have to be cabined, otherwise they sweep in everything.
Justice Kavanaugh?
You encouraged us to focus on the real world, and I agree with that. The government says in the real world, your position, however, would be, in their words, highly destabilizing. And I want you to respond to that. And also, in doing so, question of, as you survey all the cases out there, is the government regularly prosecuting cases under this theory that you think cannot be prosecuted as you see the law?
Well, Justice Kavanaugh, it's a little tricky because when the government makes those statements, there's very few citations in its briefs. So I'm going to do my best, which is, as I said to Justice Thomas, my understanding is the government sometimes brings prosecutions like this for frustrating DBE requirements. There are other fraudulent inducement type cases. The court's holding another one right now that get brought. It's not the predominant government theory in the property fraud statutes. Again, classic fraud, as I was explaining to Justice Kagan, involves somebody who schemes to take money and give something of less valuable. That's usually the whole point of a scheme, not to give something of equal value. And so I think it's an odd situation, but when you get into, perhaps government officials that the government thinks are corrupt. You get into other, programs that are important to the government. I don't deny that the DBE program is quite important to the government, just as a mask mandate might be very important to the government a few years ago, and other regulatory interests, like the one in Kelly, are very important to the government. And so sometimes the government does get sufficiently frustrated that it brings these cases. I don't think it's highly destabilizing to just lop off these things that are outside of ordinary understanding of common law fraud, and still leave the government with Section 1001, Section 371, and any number of other civil remedies that private parties might have available to them in these situations where somebody is subjectively frustrated but not harmed in their property.
Thank you. Justice Barrett?
Mr. Fisher, I want to give you a chance to respond to the government's argument on page 47 of its brief. It says that even under your own pecuniary loss theory, you lose because PennDOT paid more for the contract because it's more expensive to use DBEs. And so it did lose money. Do you have anything you want to say about that?
Sure, I have two things. One is the government's waived that argument twice over. It didn't make it at trial, and it didn't even make it in the brief in opposition in this court. And there's a good reason why the government never made it earlier. In the Third Circuit, the government said, and I think I can quote from the government's brief here, "We do not know whether PennDOT would have paid more for a contractor that used DBEs." So the government's theory in this case, and this is laid out at JA 96, was that this is a non-financial interest. It didn't have anything to do with dollars and cents. And so that's the theory the government ran in this case, not that we paid something and got something, paid money and got something less valuable. But we got everything we wanted, and this brings me back to the Justice Gorsuch's question. The prosecutor at closing said, this is like a frustration of a Buy America provision in a contract. That's exactly what the court has said isn't usually good enough. It doesn't satisfy the essence of the bargain, and it's certainly not financial in nature, but that's what the government said this case was like.
Justice Jackson?
So how do we square your argument with how the court has treated bank fraud cases? I understood, and as the government highlights, that the bank fraud statute, we've said, is modeled on the mail-in wire fraud statute. And the court in Shaw, I think, looked at the very argument that you're making and held that bank fraud does not require ultimate financial loss or an intent to cause financial loss. And I thought very notably, the court quoted Judge Learned Hand as saying, quote, "A man is nonetheless cheated out of his property when he is induced to part with it by fraud, even if he gets a quid pro quo of equal value." So it seems that with respect to bank fraud, at least, we have rejected your theory, and we say the statutes are modeled after each other. So how do we reconcile this?
I'm very glad you asked me this question because
Yes.
a lot of the government's brief hangs on Shaw and this related theory. You're right that the bank fraud statutes, at least in the states we're talking about today, are like the property fraud statutes. But Shaw poses no problem for us. All Shaw recognizes is that if the victim is later made whole by like insurance proceeds or a third party, or even if the defendant himself later pays the victim back, it's still fraud. It's still criminal fraud. Just like if you steal something from somebody's living room and then bring it back next week, or you bring them back a new TV that you've stolen. All Shaw holds is that what the common law called the collateral source doctrine, which is the defendant's made whole some other way on the back end, doesn't cure the fraud.
But what about the quid pro quo of equal value concept?
So I think
Yeah.
understood in the context of that's the holding of Shaw, which poses no problem for us. And I'm going to get to that, but I think it might be helpful before the government stands up for me to say one other thing, which is the other thing the government quotes again and again is no harm has to occur in certain cases. All that means is that the property fraud statutes are an inchoate offense, which again, we don't disagree. So now let me talk about quid pro quo of equal value. In the context of Shaw, I think all the court is saying when it uses that language is that what I just said, which is if you later get something that makes you whole,
All right, let me just
there's no
ask one
problem.
final question. I guess I'm just trying to understand why this is all being funneled through the lens of injury to the plaintiff, or not the plaintiff, injury to the victim in a situation like this. Again, this is a criminal statute. Is it your view that Congress cannot identify certain conduct related to property and money that is, it believes, wrongful if you do it with a certain intent, you create a scheme, and there not be any harm I mean, there's no completed harm element here. I know you say you're supposed to intend for it to happen, but I don't understand why that's necessarily the case. That element is not in the text.
So two reasons.
Of the
One is,
statute.
again, the word defraud is in the text, and that brings the soil of that element. And 100%, Justice Jackson, Congress can legislate to have the criminal law be broader, and it has in fact done so with honest services fraud. That is the one area in response to McNally that Congress has in fact expanded the fraud statutes. And as Judge Sutton has said, and as this court quoted for itself later from that opinion, that one singular extension actually is quite significant because it shows Congress said in this situation we want it to be fraud, but not in other situations.
Thank you.
You had this whole argument in McNally, and Congress responded just with honest services fraud.
Thank you, counsel. Mr. Fagan?
Thank you, Mr. Chief Justice, and may it please the court. Petitioners are asking this court to engraft a financial loss element onto the property fraud statutes that's nowhere to be found in their text, that this court has rejected no fewer than 3 different times, not just in Shaw, but in Loughran, in Carpenter, and frankly in Nieder too, when it rejected a requirement of damages, and that would cut out paradigmatic frauds like charity fraud, co-religionist fraud, veterans preference fraud, or basically any fraud that preys on a victim's idiosyncratic preferences. And I think the more that we hear about this theory, I think the more incoherent it becomes. And I think, I mean, frankly, that's become clearer or less clear as the case may be this morning. So charity fraud, they acknowledge both here and in their reply brief that charity fraud is fraud, but the only misrepresentation in a charity fraud case just goes to a non-pecuniary aspect of the transaction. Then you have something like the Grover Cleveland fraud, which is an example drawn straight from the restatement, although it doesn't mention Grover Cleveland. And then we have a uniqueness exception that I don't think I saw in their briefs, and I'm not sure how far it extends. Does it extend to Monet versus Manet? I don't know. I don't know where that extends. And then let's take the plumber example. The whole point of the plumber example is I'm contracting, I'm paying the price for a certified plumber to fix my toilet. I guess they'd say it's not fraud if someone comes in and says, yeah, the toilet was fixed just fine, a certified plumber wouldn't have done any better, but that's not what I contracted for. I want the peace of mind of knowing that, like, I had a certified plumber, or I wanted my preferred provider. That's straight from the restatement that Nieder cites as the materiality standard in this context. And then we have the you get coal instead of gold bars, which they concede wouldn't be fraud under their theory. I don't think this makes sense. I think the court should reject it. I'm sorry.
What exactly was the harm to the government here?
The harm to Penn DOT, I mean, we actually had evidence in this case, and we have maintained this theory. You can look at pages 11 to 12 of our brief and op and page 42 of our reply brief. There was harm in that they were willing to pay more for this regulatory program to be satisfied because they were required by the legal requirements to do it. They were actually willing to pay more for it. But in addition, Your Honor, I mean, the government was harmed because it made very clear that this was a service, this was the type of service that it wanted to contract for, and that it did not receive that particular service. It's the exact same theory that would be the case in veterans preference fraud. If they'd contracted to have a veteran do this, and someone lied and said they were a veteran, I believe they're saying that's out now, unless it's under, I wasn't sure whether they were accepting the idea of a specific performance exception that Justice Gorsuch mentioned,
Mr.
and
Fagan,
how far that would extend.
You say that the government was willing to pay more for DBEs. Did you preserve that argument?
Yes. You can look at page 42 of our Court of Appeals brief. You can look at the closing argument the government made.
Mr. Fisher says that's not in the case. Why do you disagree?
I disagree because we both presented evidence on it and preserved it. I mean, the court is free to look at the record.
So if that's the case, why are we here? I mean, if in fact there is an injury and it's economic, can't we resolve the case on that ground?
I think the court could do that, and we urge the court to deny.
If there is an injury requirement, it was satisfied here.
Yes,
Okay.
we have made that argument. I mean, we introduced that section by citing the portion of the brief in op where we made that argument. I'm happy to, point the court again toward it.
let me ask-
I mean, I still.
That's fine, that's fine.
Yeah.
That answers my question completely. Did you agree that a common law fraud, completed fraud, required injury?
It depends what you mean by injury, Your Honor. I think they get a lot of mileage out of confusion in the cases about what phrases like harm, injury, and loss mean. I mean, I agree that it requires harm in the sense that you have to obtain the victim's property, but here that's satisfied. They got tens of millions of dollars of Penn DOT's money. So in that sense,
Loss.
yes. I do not agree that the common law required the kind of net financial loss that they have here. First of all, I think that's essentially, they essentially concede, and this is at page 9.
Not net loss, but that there's some deprivation of property, some damages?
No, Your Honor, there didn't have to be damages, as we point out, particularly for the rescission remedy. And on page 9 of their reply brief, they acknowledge that the common law was established in our favor at least by 1952, and Pasquantino, page 360 of that opinion, tells us that 1952 is the relevant date for wire fraud. Now, I would
Mr.
submit
Fagan.
that this, sorry.
I just wanted to ask you, kind of following up, Justice Gorsuch is asking whether we could decide the case on a narrower theory, and I wanted to return to, kind of related to that, I wanted to return to, Justice Kavanaugh asked about whether this would destabilize the law. He asked Mr. Fisher that question. Justice Thomas asked how many of these prosecutions are there on this DBE theory. How often does the government, it doesn't have to be just DBEs, but how often does the government bring prosecutions that might fit this kind of category? Is this an outlier or is this something common?
I can't give you a precise number, Justice Barrett. I mean, I think in a lot of cases we also would be able to show some kind of economic loss of the sort that we're supposing. But we definitely prosecute cases of charity fraud. We definitely prosecute cases of veterans fraud, and there are other types of fraud that we prosecute under this theory.
Well, if you can't give a number, how can it be highly destabilizing, or if you're not?
Well, one reason I think it would be very highly destabilizing, to get back to what I was just saying, is I don't really understand the limits of this theory that they're espousing. It's one the court's rejected numerous times, and I don't even understand where it's coming from. I guess, although all they objected to below was the property element, I take them today to be locating it in the defraud element. But of course, in Shaw, the court rejected the idea that intent to defraud requires intent to cause financial loss. So, but just taking it on its own terms, I mean, I guess they appear to draw this from the common law, but they concede the common law was established in our favor by 1952, and I think it was well established long before then. If you look at the Story Treatise from 1870 at section 203E, page 207 of the 1870 Story Treatise, Story says that you're entitled to a rescission remedy if either you pay a higher price or you were tricked into making an exchange that you otherwise wouldn't. And that's
I'm sorry, why don't you finish your thought?
I'm sorry, and that's exactly the case here. It's the same for false pretenses. If you look at the 1865 version of the Bishop Treatise that we cite in our brief, we cite the 1883 version. It cites the horse cases and points out exactly our rule. I'm sorry, Mr.
No. It seems to me this case has a lot of the air of a pot calling the kettle black. I mean, if we took the phrase, there are no limits to their theory, I don't know which side would have more statements like that, but there would certainly be a lot in either one. So I'll ask you the same question that was asked of Mr. Fisher. What is the limits to your theory? That's a big part of the argument on the other side, that you're taking however minor, okay, let's say it says, you can get as many hypotheticals as you want. The contract says, and all the documents shall be printed on 8.5 by 11 paper. and you get 3 of them that happen to have 8.5 by 13 paper. Can you bring that prosecution? You know, maybe you wouldn't normally, but you may well have reasons that you don't like what happened, so you're looking for anything you can get your hands on to throw it out or get some disabling aspect to it. And if it's 1,100 pages, there are going to be a lot of things in there that they, you know, didn't dot every I or cross every T. So what are the limits to your theory?
Well, Your Honor, there are other limits in the statute that we may get to later, but the principal way that this has been dealt with and the way this court dealt with it quite recently in Universal Health Services, where it begins the discussion with the NEDR standard, is through materiality. And the court makes clear in Universal Health Services that this exact problem, there in the context of conditions on payment, but I think equally translatable to other types of contract conditions. The court makes clear that the standard's the same in criminal law, tort law, contract law, and that standard is familiar and rigorous, and that the standard excludes these kinds of sort of you might call them ticky-tack things, unless, and this is at footnote 5 of NEDR where it cites the restatement, there is a subjective preference that this particular victim happens to have, of which the defendant has constructive knowledge.
What about the point that a lot of these things could be dealt with under state law, and you don't have to federalize every jot and tittle in a large contract, and that it's a matter of concern that we've expressed in many precedents that the federalization of something as simple as nuances of contract law is a very serious matter.
Well, let me emphasize again that this would not, for the same reasons as in universal health that the court explained there, federalize every jot and tittle of a contract. And I can explain why this is a very different case from what you're supposing, Your Honor. But just to take your question on directly, I take the instinct, and let me say a couple of things about it. Number one, I think it's always been a supporting rationale, not a freestanding reason just to impose a limit in the statutes. For example, small bore private frauds, the Justice Manual advises prosecutors not to bring those types of prosecutions, but I don't think you'd say, and this goes to my friend's colloquy with Justice Kagan, I don't think anyone would say that that's a justification for writing such an exception actually into the statute. And by the same token here, I don't think there's a reason why, if just a freestanding reason, why to do that. Congress wrote these statutes because it wanted to criminalize frauds when they used the mails and the wires, and that's what we have here. As I was just explaining, this is a very traditional theory of fraud. I think it's common ground that it's at least been the law of fraud for the 72 years that
Mr. Fagan, I'm sorry to interrupt, but I just want to circle back to the Chief Justice's first question, and materiality has never been that high of a bar. You seem to be trying to make it a little higher here by really importing, it seems to me, the benefit of the bargain idea with respect to individual items that can sometimes give rise to injury even when you're given a thing of equal value. The horse example, the painting example. On your theory, though, of materiality, if materiality is the only thing required, what about the babysitter who says, I'm going to, and it's in the briefs, take the money that you give me for college, and therefore I hire her. She provides excellent babysitting services and proceeds to blow the money on a trip to Cancun. Now, is that mail fraud? I mean, could that be prosecuted as mail fraud? Because I had some subjective wish that she use it for one purpose rather than another, even without any economic injury to me?
Well, Your Honor, I don't think some subjective wish counts. So if we look at footnote 5 in NEDR, it has to be a subjective preference about which the victim had constructive knowledge.
Spot me that. We got that here.
So, Your Honor, if the hypothetical babysitter says, knows that this couple
Yes,
is
that's important to them, yeah.
choosing between
Yep.
babysitters.
It's a material misrepresentation.
Considers it a form of charity, essentially, that we choose this babysitter over this babysitter. She knows that,
Yep.
or he knows that, and he lies about
Yep.
it.
Yep,
And
yep.
that's why
You're
they hire
repeating
the
my
babysitter,
hypothetical.
and there's involvement of
I think the answer you're reluctantly
Yes.
getting to is
no,
yes.
I'm just pointing, this is the exact same theory, Your Honor.
Now,
under which-
I would acknowledge, I would acknowledge if I had paid more for the babysitter who's using her money for good things, rather than the babysitter secretly planning a trip to Cancun, that might be, I might have been injured. But on your theory, that's not required.
So, Your Honor, let me just say a couple of things about
That's
that.
federal mail fraud.
I think that's exactly the same theory as charity fraud. I think it's exactly the same theory as if there's a misrepresentation about a criminal background and turns out to have been a serial child abuser. I think you could
No,
imagine...
in those
this-
circumstances, I might have paid more, and if I can prove that, I've certainly been injured. But
Well,
you would have us say that doesn't matter, so long as the victim's aware of the subjective wishes, that
You
is
might have-
mail fraud.
Sorry, Your Honor, you might have paid more, but maybe not. So this is an actual case from the 10th Circuit, a case called Richter, where there's a company that represents that it's going to dispose of your electronics in some kind of environmentally sound way rather than simply to dispose of them overseas as other companies do. And they charge about the same rates as other companies, and people say, oh, this is a great deal. And it turns out they're taking them overseas too. Or to make this a little bit more like the babysitter example, you could imagine a babysitting company doing this sort of thing on a systematic basis, or take an actual company. They're not doing what I'm about to
I take your point.
hypothesize
I
they do.
think Justice Kagan had another question.
I'm sorry.
Well, it really comes off of Justice Gorsuch's example, and he beat me to the punch a little bit because he said, you know, if this exact same lie, I'm going to use the money I make, this babysitter says, in order to go to college. On the one hand, that gets her the job. On the other hand, it gets her the job plus 25 cents more an hour. The question is whether that should be the difference between wire mail fraud and not. Now, hopefully, the wire mail frauds statutes are not being used to prosecute the babysitter regardless. But what sense would it make? If I understand Mr. Fisher's theory, it makes all the difference between somebody saying, you know, this is such a wonderful person, she's using this to go to college, they give her the job on that basis, but because they also say, we'll throw in an extra $5, that's what's going to make the difference between fraud and not.
That's not necessary, Your Honor. I mean, this is the exact same theory as in veterans preference fraud. If you're paying the same amount, but you really want a veteran to do it, I mean, it's the exact same. Your Honor, if I know, like, there's always an instinct to want the advocate to give up these hypotheticals. That is the exact theory of charity fraud, veterans fraud, co-religionist fraud. I hire somebody to build my pews, and it turns out they're a Nazi. That is our basic theory of fraud. It's not required, and in fact, Universal Health Services uses an example. One of the examples of a common law fraud case that they cite involves employment fraud, where somebody misrepresents their qualifications on their resume, says they were retired, and it turns out they were actually in jail during that period.
Mr. Fagan.
Mr. Fisher has said a lot of these cases use the language of harm, use the language of injury. I mean, some of them do, some of them don't. They're a little bit all over the map as far as I understand them. But there are definitely some that use that language. What do you take them to be referring to? Or what's the range of things that they might be referring to? In other words, some of them are using them one way, some of them might be using them another way.
So, Justice Kagan, let me make very clear just a couple of points before I address your question. They're very quick. Number one is the court made clear in Pasquantino and also in Nieder that the burden's on them to show the common law, and they have to show a well-established common law rule. The second thing I tell you, and this goes straight to your question, is we're not claiming every single case has to be read our way. We acknowledge, for example, we cite the Lefebvre treatise that points out that the law on false pretenses was more in our direction, but that there were some other cases about this. And then the third thing I would say is a lot of these cases do talk about loss, harm, loss and harm in terms of just actually not getting what you want, that like getting the coal instead of getting the gold would be the loss or harm. If you want to see a more close in time discussion of that, there's the Washington Supreme Court opinion in Rudebeck that we cite in our brief, and I don't think they really have a response to that. In fact, there are a number of sources, contemporaneous sources, that they don't respond to in our brief. I mean, for the common law, I'm content to let the court either look at it for itself, or I'd encourage the court to line up our sources versus theirs and see what they're not able to respond to in the reply brief. And again, finding a couple of outlier cases or a couple of cases like the ones that Mr. Fisher has focused on this morning that I could talk about specifically, but even spotting him that those favor his rule, just a couple of cases lined up against all the treatises, you know, Story, Bishop. This court cites Bishop for all sorts of things all the time.
Counselor, the fraudulent inducement cases are difficult because the babysitter one doesn't think of the contract as including what the person's going to do with the money later. But presumably, if I am a parent and I really want them to spend the money on college, I could make it a part of the contract, couldn't I? Explicitly.
Yes, you could, Your Honor, make it explicit
Now,
in the
this case,
contract.
this is not fraudulent inducement in the sense of those examples of my reasons for entering the contract. The use of the DBEs was part of the contract, correct? Written part of the contract.
Yes, Your Honor, and let me be clear that it's not neither a necessary nor a sufficient condition for it to be part of the contract. This goes back to my discussion with the Chief Justice.
On the materiality.
On materiality. You could have lots of things in a contract. This came up exactly in Universal Health Services. Even if they're specified as important or material or conditions of payment, that aren't such because it's either not reasonable. This is under the standard that Nieder employs. It's in footnote 5 of Nieder, because either a reasonable person wouldn't attach importance to it, or there isn't the kind of subjective importance that the victim had reason to know
I'm just
about.
getting to the point that this is a much narrower case than the broader fraudulent inducement cases, correct?
It's narrower than a case where there's like 7,000 requirements and they're all material, and in theory we're trying to prosecute for one. I'm not sure we could do that unless it were
But it's
obviously an important one.
It's not a condition of the contract that's not specified in the contract.
It is not only specified here in the
Counselor,
contract.
just
yes.
answer my
Yes.
question.
It is this is not
different.
that case.
This is not the case of the babysitter.
That is absolutely
All
correct, Your
right,
Honor.
thank you.
This is no.
Why are you fighting me so hard?
But you're,
I was not trying to. I apologize for giving the impression I was trying to fight you. I was going to amp up your point, actually.
when you were answering or discussing this issue with Justice Gorsuch, he said, I think your answer is yes, ultimately, but you never actually said yes. Was your answer yes to?
Yes, Your Honor. I will accept that under the theory that we have, which is necessary to get charity fraud, veterans fraud, co-religionist fraud.
I got the reasons. I just wanted to make sure.
I'll accept that if the mails and wires were used and all the elements of the statute were satisfied, yep, that would be wire fraud. I think the sentencing guidelines would be pretty low.
Right. And then on materiality, which you emphasize as being a critical limit here, what should the jury instruction look like there? What is the standard jury instruction there? Because you refer to essence of the bargain, which I think is probably not giving a huge amount of guidance.
So, Your Honor, I don't think there's a one-size-fits-all approach to this. And let me just get the difficult part out first. They've identified a couple of instances in their brief where the government opposed an essence of the bargain instruction. The government should not be doing that. And we've filed a corrective letter in one case, and the other case is post-verdict, and we intend to confess error in that case as well. So I think in footnote 5 of Universal Health Services, the court offers just a number of different formulations, some of which might be useful in certain cases, some of which might not. I don't think it's error just to use the standard materiality instruction, because of course that's what Universal Health Services is interpreting. But something like essence of the bargain, or what was done in this case, I think it's page 98 to 99 of the joint appendix. You have fundamental basis of the bargain. That might be another way to put it. I think what's important is that the jury gets the idea of the actual materiality standard, like that really the government's, if it's not something to which a reasonable person would attach importance, like the size of the paper, Mr. Chief Justice, then we're not going to be able to satisfy that. And then I think you're really going to have to show, and the burden's always on us to show, this is even beyond Universal Health Services, which brings us up in a civil context.
One concern, and I don't think there's a great solution to this, but I'll just throw it out there, is that obviously it's pretty vague, and different juries are going to have very different reactions to something like essence of the bargain. But I don't know that there's a great solution to that. That's why I was asking the question about how it's spelled out.
So, Your Honor, I think courts have a lot of experience crafting proper jury instructions. This is exactly what they'd have to do under Universal Health Services. Unlike Universal Health Services, we have to prove this beyond a reasonable doubt. And I think any kind of reasonable explanation, and again, this has been the law for a long time. So there's a lot of experience with this, but I think any explanation that the court comes up with that's a reasonable explanation of the concept of this has to be something that was really important, like here, where the contracts only occupy 7 pages of the JA, which are smaller pages, Mr. Chief Justice, than 8.5 by 11. It only occupies 7 pages of the JA. They only have 17 warranties, and this is the only one designated as material. That's going to be easier to prove. One other thing I'd say about materiality is, of course, net pecuniary loss or the lack thereof is something that could be a factor in whether something is material. People care more if they're losing money. They care less if they are not losing money as a general matter. There are cases, and the restatement recognizes this, NEDR recognizes this, the law has always recognized this, the uniqueness exception recognizes this, if there is such an exception, rather than that just being the general rule, that there are cases where someone has a subjective preference that may even cut against their economic interest. I would like to pay more. There are going to be cases, and this goes back to my discussion with Justice Gorsuch, there are going to be cases where I'm willing to pay more for something that somebody else thinks is valueless.
Mr. Fagan, do you understand? I just want to be sure that I have the nub of your argument on essence of the bargain. Do you understand that to be ratcheted up from materiality or synonym for materiality?
I understand it to be a way of expressing materiality that is useful in the contracting context, Your Honor. And what it expresses is this idea that it has to be a but-for reason why the contract was entered into, and that you have to show it's either something reasonable.
But is that more than materiality? And does it? Well, 2 questions. I mean, Mr. Fisher said that essence of the bargain is an effort to ratchet it up. So do you agree or disagree?
I don't agree, because if you look at Universal Health Services, like it's a 3-page discussion, but it's clearly equating these things as synonymous. I think it's a context-specific application, and the thing that you're getting, the essence of the materiality here is whether or not it's going to influence the person to enter the contract.
Does this idea, essence of the bargain, have any grounding in the common law of fraud?
Well, Your Honor, yes. I mean, where the essence of the bargain standard comes from is a citation to Story, I believe, who mentioned essence of the bargain. I think the court, but that's not, I wouldn't get I mean, that's the formulation that we've found most useful, but I think, as I was explaining to Justice Kavanaugh, if in footnote 5 of Universal Health Services, and my apologies if I'm misremembering that comes from Justice Story. Obviously, that's an objective fact you could check. But there are a number of different formulations, and the common, which I think show that the common law has kind of incorporated this requirement, but it's the basic materiality. It is the basic materiality standard, but is applied in this context. If you're going to talk about something that these kinds of very small bore things that aren't obviously important to any reasonable person, there's going to have to be some evidence of like enforcement. We rejected contracts for failure to do this. We have that kind of evidence. We have that kind of evidence here, and that the government's really going to have to prove up its case, particularly in the context of a criminal prosecution where the proof is required to be beyond a reasonable doubt.
Thank you, counsel. If you're
I mean, I think the other things I'd emphasize are that this just the requirement they're trying to impose. Well, I ran out of time, so there you go.
but we haven't. Justice Thomas? Justice Alito?
On the question whether we could affirm the decision of the Third Circuit on the ground that PennDOT actually paid more here because of the DDE requirement, did the jury instructions say that proof of that was essential?
The jury instructions didn't say the proof of that was essential, no, Your Honor.
They permitted conviction without proof of that?
I believe the jury could have found on either theory. I think this would be essentially a harmless error argument.
Right, it would be a harmless error argument. So we would have to find that it was harmless or send it back. Well, we couldn't reach the issue of whether it was harmless unless we accepted Mr. Fisher's general theory, right? Because otherwise there would be no error.
I mean, I think the court could potentially assume error and remand for harmlessness, but I would urge the court not to do this. There's going to be some other case. There have been other cases raising this question. You know, I don't know why this is necessarily obviously you all would know more than I do about why this is the one that the court selected. So I don't want to have a Marshall McLuhan moment here, but if the court thought that this case best presented the question, I would urge the court just to decide it, or it's going to keep being an argument that is being raised.
Well, I'm going to ask you a question that I really would like to ask Mr. Fisher, but I can't ask Mr. Fisher any more arguments. So perhaps if I ask you, he will see fit to address it. And
would you like me to answer it as him or as me?
Whichever you want. Assuming his persona and answering for him might be
That might be fraud, Your Honor. I prefer not to do it.
It might be a thrilling moment for you, but what do you understand to be his argument about the exception to the general net benefit rule for the situation in which the thing that's involved is something unique?
I mean, I don't really understand it because I took this to be the general rule. Again, the grandfather example minus Grover Cleveland is drawn straight from the restatement. I don't really, you know, I'm not quite sure what's unique. We've got a Jets-Giants riff on that in our brief where you want Giants tickets and you get Jets tickets. I mean, is that unique?
Equal.
Well, particularly with
Please continue.
I'm not sure. It at least encompasses, like, I would take him to be saying it at least encompasses something unique like my grandfather. But I don't know how far it extends beyond that, and I don't really think it was an exception. I think it was the rule. So I'm trying to wear his hat and mine, but he may be better able to address that on rebuttal.
Now, let me ask you about the argument that I think is kind of hanging over this case like a cloud or a fog, and that is the suggestion that when you take a line of cases that the court has handed down in recent years, all of which I think I have joined, Skilling and Simonelli and Kelly, and maybe you could throw in McDonald, and maybe there are a few others. What they really stand for is that the court really doesn't like the federalization of white-collar prosecutions and wants that to be done in state court, and is really hostile to this whole enterprise.
Well, can I just say two things about that?
So those decisions under this fog don't have so much to do with the language of the particular statute or the particular situation that was presented by those cases. It's just this general attitude, and the petitioner here wants to take advantage of that attitude.
Well, two things about that, Your Honor. One, as I said earlier, I mean, I take the sentiment, but I don't think it's a reason. I think it's always been a supporting reason. I don't think it's a freestanding reason to carve an exception into the statute. Number two, this is an exception that or a new element that the court has already refused to create. Carpenter rejected a requirement of monetary loss. Nieder rejected a requirement of damages. Loughran rejected a requirement of risk of financial loss. And then Shaw rejected a requirement of either ultimate financial loss or intent to cause financial loss. I think that pretty much settles this question. The court can resolve this case on that line of cases rather than the kind of more amorphous sentiment expressed by some of the others. And I don't think this court wants to send a signal to the lower courts that it's okay to start making things up in a statute because we disagree with Congress's policy choices about how broad to write the fraud statutes. It wrote them broadly because frauds are very inventive. There are any number of ways you can defraud people, and the federal government had a separate sovereign interest in that when they implicate the mails and the wires.
Would you agree that in the end this turns on our understanding of the common law of fraud?
No. I think it is, I think they have to have a well-established rule, and we only look to that if the text is unclear. If you just want to look at the text of the statute, you got words like false representations, false promises. This is one of these cases where it's very difficult to tell what element we don't meet, and they're trying to incorporate a very counterintuitive definition of fraud. I think anyone who receives the bag of coal rather than the bag of gold is going to feel like they were defrauded, as in a number of the other examples that have come up. And in order to cut against that, I mean, I don't even think the court needs to get to the common law, and if it did, it's got to be well established. And and it certainly wasn't by 1952, even they acknowledged that.
Thank you.
Justice Sotomayor?
I thought that the only thing you wanted us to do was to say that we reject petitioner's net pecuniary loss requirement, correct?
Yes, we want you to.
But do you want us to go further? When you're responding to Justice Alito, what more do you want us to say?
I don't need the court to say, I mean, I'm not asking the court to say anything more than to reject petitioner's theory in this case and affirm the prosecution.
Okay.
Or affirm the conviction.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh? Justice Barrett?
Just one question, picking up on Justice Alito, talking about the line of cases that we've had recently. I mean, it seems to me another theme in Mr. Fisher's brief, and that kind of what makes it a little bit hard for you, is to say, like, what is the point of Simonelli? What is the point of these other cases if the government can just get around it through this theory?
Okay, so I think if you'd like a full answer to that, I think I could walk through the actual case.
Well, you don't have to give a full answer at
this
point. You can give a clip.
We were very upfront about this in Simonelli, that this was the theory we were running, and the court remanded for its more traditional theory, its words, traditional theory of property fraud. So I think, we were very upfront about that. And in cases like McNally and Skilling, the court has always reserved the question of whether some kind of property fraud prosecution could be brought. And just to preemptively address what he's about to say, I don't think this would cover Skilling or McNally because I don't think their object was property in the hands of their employer by concealing their conflicts of interest. The property that McNally wanted was the property that was the kickbacks, which were coming from the person receiving the government contracts. So it was their money that they were kicking back to McNally. That's why he wanted to keep his job. And in Skilling, he wanted to keep doing his stock fraud. So I'm not really sure that this would cover either of those cases.
Justice Jackson?
Isn't Nader and the old soil concept really relying on assumptions about congressional intent? It has to be well settled, because I thought the logic was, if these are well-settled common law concepts, then when Congress uses the language in a statute, they intended to incorporate that concept.
Yeah, I think that is a background presumption that this court often employs. But here, I think that cuts clearly in our favor, both on the 1952 point, and if we want to look just at the mail fraud statute, one easy thing to look at is, I think even they concede, and this is in the McCleary article in their reply brief, that this was getting well established, at least on their view. We think it was earlier, but at least shortly after 1872. And in 1909, Congress amended the mail fraud statute to codify this court's decision in Durland, which makes quite clear that fraudulent inducement type circumstances are covered. And if the law on our point was getting more clearly established by that time, I think that destroys any ability they'd have to show that it was well established in the mail fraud statute, let alone by 1952.
Thank you.
Thank you, counsel. Rebuttal, Mr. Fisher?
Thank you. I have 5 points I hope I can get through. First, the question here is whether the product or service that was bargained for in a particular manner, there was assigned a premium to doing it in a particular way. It's not whether the victim subjectively would have paid more. But even on that basis, Justice Gorsuch, you asked a lot about this, I'd refer the court, first of all, to the brief in opposition. I don't see that argument anywhere. Second of all, in the joint appendix, the prosecutor says this obligation was non-financial in nature. It was not about dollars and cents. In the Third Circuit, here's what the government told the court. We do not know whether PennDOT would have been willing to pay more for these same repairs. And there's also potentially equal protection implications to the notion that it would pay more simply for DBE participation. So this is the babysitter case. This is a case where the defendant made a promise to use the proceeds in a particular way that was frustrated, and it was non-financial in nature. Second of all, Mr. Fagan talks about the common law, and he talks about it as of 1952. What the court has said is that the mail and wire fraud statutes are the same. The mail fraud statute was enacted in 1872, so the question is about 1872. Even in 1952, all Mr. Fagan has is rescission law. That's equitable law under contract. Even then, the common law remained as a matter of deceit for tort principles and false pretenses for criminal law principles, that you needed injury and harm to a property interest, and that was the common law all the way through. And I would just refer the court back to our briefs. The government cites lots of quotes out of cases and treatises, and I, just like Mr. Fagan, encourage the court to look back at those. What you'll find is all they say things like, if somebody else, a third party, covers the loss, that's not fraud, or the fraud doesn't have to be completed. It's about the scheme as devised if it were completed. That's all those things say, and that's all that Shaw says. As to materiality, I don't mean to be difficult here, but I am truly baffled at the government's argument about materiality. Universal health, what Mr. Fagan refers to again and again, says something that does not meet the essence of the bargain standard is a Buy America guarantee. If you look at page 96 of the JA, where the prosecutor explains how the DBE requirement worked in this case, they say it's exactly like a Buy America guarantee. So I don't understand how you put those two things together. And Justice Barrett, you asked about the common law, look at the restatement. The restatement is crystal clear that essence of the bargain is higher than regular materiality. And Justice Story doesn't say anything to the contrary. And we cite that in our reply brief. Justice Alito, you asked about the uniqueness exception. My rule is about whether the whether the victim got something of less market value. And so the only possible exception is for uniqueness, where market value is so subjective in that context, you might say that's different. That's the Horse Called Charlie case. And even that case from the main judicial court said, we don't lay down any general rule. This is a special case. So if there's a special case, it's not the rule, it's the exception. And then finally, there were several questions about this, what it would do to the court's old cases. It's not just Simonelli that would come out the other way. And McNally, the prosecutor, could have, and Justice Stevens noted this in dissent. The prosecution could have just said, they hired a person that would conduct his services honestly, and that's the kind of employee they wanted, not somebody else. And when they paid him that money for his services, they were defrauded. That theory would have been available. And in Skilling, on the facts of Skilling, it wouldn't come out the other way, but the city manager hypothetical that Justice Ginsburg describes as classic fraud would be fully chargeable under the government's theory. So you have this odd situation where the government is here today saying, look, for 40 years, we ran a bunch of different theories. We created honest services. We created right to control. We've concocted one theory after the other. And now it turns out, oh, we were wrong. It's so easy. All we have to do is this property law, this theory. And Justice Kagan, you asked this at Simonelli, like, why not just say the property, the money under the contract is the harm? Well, there's a really good reason. It's because the common law was clear that wasn't enough. And all the sources we cite say that's not enough. The court in Durland and its early cases where it said, here's what the ordinary meaning of fraud is. It's harm to a property interest. There has to be loss. And so when you understand that and you look at cases like the Kansas Supreme Court case in Palmer, the Arkansas Supreme Court case in Morgan, there aren't a ton of cases like this because the government didn't actually charge this back in the old days. But when they did, they were rejected, except for in the Horse Called Charlie situation. Otherwise, it was rejected. And the court's own cases rejected. And so all the government is doing is trying to basically throw up its hands and say, all of our other theories we tried haven't worked. Now we're going to give you this last-gapped effort of denying the reason we created those whole theories in the first place, which is that the common law requires harm to a property interest. And that understanding, and Justice Jackson, this brings me to your question, that understanding is baked in the statute. We don't think we have to meet the Nieder test, like for materiality, where you're just inventing an element that isn't in the statute. The word defraud is there, and so we have the better reading just under ordinary principles, but even if we had to satisfy Nieder, we could.
Thank you, counsel. The case is submitted. Argument next today in case 23-861, Feliciano versus the Department of Transportation. Mr. Tutte.
Thank you, Mr. Chief Justice, and may it please the court. This case turns on the meaning of the word during. Under the differential pay statute, the government must provide differential pay to its civilian employees who also serve in the reserves when they are called to active duty under a provision of law referred to in Section 101A13B of Title 10. Section 101A13B refers, among other provisions, to any provision of law during a war or a declared national emergency. Thus, during a national emergency, reservists called to active duty under any provision of law must receive differential pay. The government resists this common sense temporal definition of during, the same definition it argued for in Rassam. Instead, the government says during here means, quote, in the course of, end quote. And in the course of, it says, requires a substantive connection between a reservist's military service and a pending national emergency. That is wrong for at least 3 reasons. First, it conflicts with the ordinary and conventional meaning of the word during, which is virtually always purely temporal. Second, it doesn't work in the statutory scheme, which asks only whether a reservist has been called to active duty under a provision of law referred to in Section 101A13B, something that doesn't depend on the reasons the reservist was called to active duty. Third, it would create an impossible line drawing problem to figure out what it means to have a sufficiently substantive connection to qualify for differential pay. Not just for courts, not just for agencies, but for private employers who will face criminal penalties under 18 U.S.C. Section 209 if they get the question wrong. The government has yet to offer any theory for how to assess whether a reservist service is in the course of a national emergency, other than saying courts should defer to the government's own characterization in a reservist's orders. There are more reasons the government's interpretation is wrong and ours is right, but I see that I am out of time. I welcome the court's questions.
How do you respond to the government's argument that your approach would be very disruptive in the other sections of Title 10 that use the term contingency operation?
Your Honor, this case doesn't actually turn on the definition of contingency operation. Congress picked up a part of the definition of contingency operation and used it as a reference for the differential pay statute. But we think that the court's ruling in this case wouldn't alter the meaning of the word contingency operation in Title 10 in any manner. Moreover, I'll point out Mr. Feliciano was called to active duty under Section 12302 orders to do the exact same duties that he had performed under his 12301D orders. The 12302 orders are enumerated in the statute, meaning that under the government's theory, he was already participating in a contingency operation, according to them, when he was called under 12302. But the government hasn't pointed out that he was, and I don't think that they think that he was, because there are other separate limits on what it means to be a contingency operation. It must be a military operation, and it must result in a call to active duty under a provision of law. Yes, Your Honor.
Has your approach ever been the prevailing approach?
So, Your Honor, we have canvassed all courts that we can, and essentially this has not been litigated, as far as we can tell, in the courts. The MSPB judges have consistently sided with us until the Adams opinion. There were a couple of outliers. But, and we think that in the O'Farrell decision, which predates the Adams decision that is the adverse precedent in the Federal Circuit, there was a suggestion in that case that a contingency operation has to be a military operation that puts American soldiers at a risk of armed conflict, that the military operation part of the definition is doing a lot of the work in the contingency operation definition. We think you don't have to reach any of that in this case because of the way that the differential pay statute uses 101A13B. What it says is you are entitled to differential pay if you are called to active duty under a provision referred to in 101A13B. And it's the conventional common sense reading of what it means to be referred to in that provision that provides the trigger for differential pay. During a national emergency, any provision of law is referred to because it says any other provision of law during a war or during a national emergency declared by the President of Congress.
But isn't the practical effect then of your reading that every reservist gets differential pay who's called up?
Yes, called to active
Who's
duty.
who's called to active duty. And I guess what I'm confused about is why Congress would have so carefully amended the statute over time to add new people, et cetera, if the right reading was just, if you're called up, you get it.
Your Honor, shortly after the statute was enacted in 2009, the Office of Personnel Management issued guidance that said that anyone called up under the residual provision, the any other provision of law provision, could never receive differential pay. So if it wasn't enumerated in the statute, you couldn't get differential pay at all. So Congress had a strong incentive to ensure that new provisions were added to the enumerated list.
Yeah, but if you're right, wouldn't the amendment be, no, everyone who's called up gets it? That's not how the statute reads in terms of either what Congress did in the successive amendments or how it reads right now.
The way we look at this statute is as very much a creature of Congress and how Congress actually works. So the issue is that there were the votes to enact the original differential pay statute. It took almost 10 years to enact that statute. It's a lot easier to add a new enumerated provision to 101A13B than it is to overrule OPM's guidance on this issue. So, you know, the way that we think about it is that probably a member of Congress had a constituent who said, you know, I was serving on compulsory orders and I didn't get differential pay. And the member of Congress said, well, we'll get that fixed. A lot of these statutes were enacted as part of omnibus appropriations bills. So Congress has seen this as something where people can get this amended and changed, and it's easier to do something small than it is to do something big in Congress, and it's easier to add a new provision to just make sure that your constituent gets
Wasn't it
differential
easy?
pay.
I'm sorry.
Go ahead.
If that were the case, why didn't the various provisions that were rejected and proposed to Congress to just say differential pay for anybody called up? And there were quite a few of those that were rejected. Instead, Congress crafted a very careful limitation.
Your Honor, let me give you 3 reasons that we think Congress wrote the statute this way and not by simply providing differential pay to all reservists. First, they're not the
You're
same.
not denying there were proposals to do that.
There were proposals to do that.
And those were rejected.
I don't want to say that they were rejected. I want to say they were not enacted. This text was changed to this text.
Okay.
And the reason why I make that distinction is that I think there were members of Congress who supported this language because they knew it would function exactly this way. I think there may have been other members of Congress who are more optimistic about the ability of the Congress and the President to actually end existing national emergencies and might see this as a real limitation, as something that is actually capable of constraining the availability of differential pay. Again,
When was the last time there was not a declared national emergency?
my understanding is that the National Emergencies Act ended all pending national emergencies in 1976. So when Congress saw that there were 4 pending national emergencies, that they thought that this was far too many and that national emergencies had gotten out of hand, and they
But since 79, there's been one in effect. Sorry to interrupt.
Yes, Your Honor. There was a national emergency declared with respect to Iranian sanctions.
And that's been renewed by the president routinely, and it's been in effect since 1979, I believe.
Yes, Your Honor, and I thank you. I think that that's crucial. Every single year, these national emergencies are revisited by the president and renewed. This is not like there's been one national emergency and it's been sitting out there. The president revisits it, looks at whether the basis for the national emergency continues, and then redeclares the national emergency.
How does that help your argument?
Because it means that national emergencies are actually national emergencies. So, I mean, if we focus on the differential pay statute, it says during a war or during a national emergency. And it is completely legitimate to believe that Congress thought that national emergencies are actually national and actually emergencies, that they are all of nation efforts that they don't want to create line drawing problems where you have to try to figure out whether backfilling for a reserve for an active duty service member who goes overseas constitutes a connection, or whether being called to training that will ultimately result in your potential deployment in a contingency operation counts. They wanted a clean, bright line rule. Everyone contributes during a national emergency.
Your thinking, excuse me, your thinking is that Congress said, well, you know, we realize that there have been national emergencies now for decades and decades and decades, but if we look ahead, we foresee the time when there will be peace throughout the world and nothing threatening, and the lion or the wolf is going to lie down with the lamb, and there isn't going to be a national emergency. So that's why we've put in, 8 specific provisions that would be superfluous if your interpretation were accepted.
2 responses to that. On the superfluity argument, this is not superfluity as we understand it typically in the law. Those provisions are not superfluous because if all national emergencies end, they will be the only basis for differential pay. So this is kind of a quasi-superfluity argument by the government that's more based on hypotheses about what Congress believes and what Congress knows about the real world. And so it calls on the court to try and figure out whether Congress really believed that they were going to end all pending national emergencies or not, which is just different than traditional textual superfluity where the
But to that point, really, what does Congress believe? There are 43 national emergencies now. Every time we have a sanctions program in place, we declare a national emergency. I mean, this is just a sort of feature of modern life.
There are politicians who go on morning news programs and say, we are going to, end the authorization for the use of military force, that we are going to end, they don't necessarily say pending national emergencies, but I think that that's a fair implication. We are always one election away from ending all pending national emergencies. They could change the way—
We're not going to have any sanctions programs. We're not going to have any hurricanes. We're not going to— it just seems like a world which couldn't possibly exist.
I also want to point out, and I think this is crucial, the legislative history, and this goes to the legislative language change, it's always been sold. The language of this statute has always been put forward as if it applied to all reservists. In other words, although this triggering condition may not have an end in sight, I want to emphasize that this triggering condition is something Congress does control. So it's not like they said, when man again walks on the moon, something they can't control. They can control when all national emergencies end or not. So they're actually sitting in the driver's seat of the scope of this statute. But this was always sold as all reservists. After the language changed, it was still presented on the exact same terms.
Well, I thought you said something completely different just a minute ago, which it was sold. It was actually your theory, which I want to explore, of how Congress operates, that some members kind of sneakily thought just listing the particular provisions would cover the waterfront and deceived the other members. And I have no doubt that happens. That does happen. But I really hesitate to put that into our statutory interpretation case law.
No, I think you should read the statute to say what it says because of the legislative bargain that was struck. This language is less than all reservists because it does have the—
But the theory of Justice Jackson's question was, well, they could have easily said all. And you said, well, they, covered all without advertising it. I think you were saying that.
I think that what happened was, we don't know what happened, but
That's another point. We don't know what happened. So why are we talking about, speculating about that to such a degree?
Well, again, we win on the language of the statute. So, if we aren't speculating and we're just going to return to ground and go to the language, there's just no way to read this statute in the way that the government wants to read it.
Doesn't during have, I appreciate during has a temporal meaning, but even in your introduction, you said it virtually always means temporal. Aren't there circumstances in which it could be construed reasonably as a substantive connection?
So, to be honest, I have not found a dictionary that says it can have a substantive connection. I think in ordinary usage, we sometimes make a connection. So, if you said the attorney was arguing, during the argument, that would mean that they were standing at the lectern, that they weren't out in the hall arguing the bailiff.
Right, so it's contextual, isn't it? Don't we have to look at context, especially for a word like during, that is so flexible and malleable to try to really understand what this statute is supposed to be covering.
I don't think during is that flexible. I mean, the court didn't think it was very flexible at all in Rassam, where you said that carrying explosive during the commission of any felony means you get a 10-year enhancement. So as long as it was at the same time as, even if those explosives were completely lawful, even if the felony was completely unrelated, you said during means at the same time as. And the court was quite clear that that's because during really can only carry that meaning. But I'll also point out that I think it's worth going to the actual text of this statute and really looking at it carefully, because it actually cannot bear the construction the government would like to place on it. On page 1A of the blue brief, it says, a caller ordered to active duty, this is in the first paragraph, under section 12304B of Title 10, or a provision of law referred to in section 101A13B. So you have to be called up under a provision of law that is referred to in section 101A13B. So if you then go to 101A13B, which is on page 4A of the...
I mean, can we pause for a second? Because if you're right on your theory, I don't even understand why we're doing that. I mean, if your theory is called up during a national emergency, why is Congress cross-referencing another provision where we have to look to try to figure out whether you're being called up in a certain way? That's the thing that is confusing to me about your argument.
So we have really looked into this, and it might be just a quirk of congressional draftsmanship. So this language was enacted as part of the bribery statute, 209, about a month before the language of the federal differential pay statute changed to match this cross-reference language. We've seen this cross-reference in about 9 other provisions of the U.S. Code, almost all of them relating to benefits for veterans. And, you know, I don't know why they are making this reference to this particular piece of the contingency operation definition, you know, because maybe they think that if they amend it in that one place, they amend 101A13B, they can get the benefit.
I'm sorry, I apologize.
Everyone.
So we're referring to 101A13B. So we get over
on
there.
page 4A of the blue brief, it says in B, it says, it lists a bunch of provisions, and then it says, or any other provision of law during a war or during a national emergency declared by the President or Congress. So there's no reference to the reservist service at all in this lookup operation that we've just done together. If you are looking at 101A13B because you are trying to figure out if differential pay is owed, and the person has been called up under a provision of law and it is during a national emergency, then they are owed differential pay. So in other words, whether they were called up under 12301D is not the question. If you substituted in a national emergency during a national emergency for 12301D, that you would get the same result without looking at whether the reservist was called active duty. It would just be the provision of law that would be referenced during the national emergency.
Whether during can have a substantive component as well as a temporal one. Would it sound natural to you if you had a reservist who temporarily, during a time of national emergency, or let's say war, was working as a recruiter? And so he's working as a recruiter and he's going to high schools and maybe to colleges too and just trying to recruit people to sign up. And someone asks that soldier, did you serve during the war? Would it be natural to say yes if you were totally removed from the battlefield, you're working as a recruiter?
Well, I think it would, but you don't have to agree with me on that. I actually think it very much would. Like, I served in the armed forces during the war. Oh, well, you were a recruiter. I mean, they might think that you're overstating what you did, but it certainly would be completely natural. And if the person was instead serving to backfill base security so that someone could serve overseas, or otherwise doing something that contributed to the war effort, we usually think that everyone, when a war is declared, is doing something to contribute to the war.
What about national emergency? I mean, because that's what's odd. I mean, it's very odd. I agree with you. It's weird to have a superfluity argument when the superfluity is created by a background historical fact rather than the text itself. I agree with you. That's odd. So let's talk about national emergency. If we're looking at during in context, putting aside war, if we think national emergencies are always ongoing, would we say, yes, I served during a national emergency as a recruiter when other people were, say, like, down helping people who had been caught in the hurricane?
So I don't think you would, actually, but I will say that this statute isn't a conversation between two people. It's a sort of a statutory command and a hyper-technical one. I mean, Congress wrote it in a technical manner. And so the question would be, are we going to import that kind of understanding of during into the way that this statute is written, which asks you to look at whether someone has been called up under a provision of law, and it then has you look at a bunch of provisions. So it just doesn't, I mean, I guess the better question under this statute would be, is the statute being used during a national emergency, which it's hard to say that that imports any kind of real-world facts.
So it says the statute being used, not as the soldier being used.
Exactly.
Or not as the order, kind of like the Texas amicus brief for the states.
Exactly. Yes, I think that they put it extremely well. I think if you want to see this argument made very well, it's in the brief of Texas and the states. I also actually want to point out some things that I think are critical. Congress actually drafts with respect to national emergencies in the very way that this statute is drafted all throughout the United States Code. It's on pages 7 to 9 of our reply brief are just, this was just like throwing a penny like a yard. Like, this was just the ones that came up first in the search. These are all statutory authorities for the executive branch that are activated whenever we are in a time of national emergency. So it does not matter that it's the Iranian sanctions regime. It does not matter. The president just gets these authorities and has them. And the government conceded that one of the more extraordinary authorities in the U.S. Code, Public Law 85804, which uses the word during, just like this statute, uses during in a purely temporal manner. And that gives the president extraordinary contracting authorities to sort of disregard ordinary contracting rules. So this is how Congress typically drafts statutes with respect to national emergencies, perhaps because they make assumptions about the nationalness and emergency-ness of emergencies that are not founded. I'm not going to hypothesize, but this is how these statutes are written throughout the United States.
So do you think those provisions permit the president to do away with all contracting rules for every contract that's totally unrelated to the national emergency? That seems to be your argument.
That is the position of both parties in this case, yes, is that is the scope of that provision.
I thought the government had changed its mind. It's going to tell me that, because it's going to have to explain why that's true in one set of provisions and not another. So that contracting for paint for the Department of, I don't know, Education that has nothing to do with the military, the government could?
I will say that there is a separate limitation then built in the statute. So the statute turns on in time of national emergency. There has to be a determination that it's essential to the national emergency. That's written separately in that statute, is I think my understanding.
Can I go back to how Congress understood this? Because I think a helpful point for you is the CBO score. Because Congress does pay attention to that, and that, you say, was based on an understanding that that would apply to everyone called to active duty. So that's a good point in your favor, I think, in my understanding of CBO scores. But the government comes back on that in its brief and, basically says the CBO didn't explain the basis for its assumption, and it was based on prior versions of the legislation. So this is not, not your usual CBO score, which, again, I think is pretty central to how Congress understands legislation.
Well, CBO didn't make this mistake. If it's a mistake, CBO didn't make it just one time or just two times. It made it over and over again. And I want to emphasize the degree of error that would be involved here. I've looked at data from the Defense Manpower Data Center, and 90% of call-ups are under unenumerated statutes. So they were off by a factor of 10 if they were estimating this based only on just the prior language of the statute. But we look in our petitioner's brief, we go through and look at other statutes that had the same cross-reference, because, like I said, it's been used in around 9 other places for veterans benefits cases or veterans benefits, and they always got it They always scored it this way. So, thank you.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
What was the CBO score?
So the CBO said that it would cost roughly $40 million a year, but that for the average reservist, it would be around $3,000
So the total bill was estimated at $40 million per year.
per year. Yes, at that time.
What is your response to the government's argument that your client is doomed to lose because he did not present the materials that were required by regulation to the FAA?
So I have three responses. It's not a barrier to this court deciding this case because it's not jurisdictional, so it would just be an issue for remand. And I'll say it's not passed on by the court below or the MSPB. We have good arguments he was not required to exhaust here. Two, one, the statute does not require it. So, the agency in some sense got a benefit here. They didn't have to pay him differential pay in real time. He had to go to the MSPB and get the differential pay. So they can just make the payment then. It's money that was budgeted to be paid to him. It should have been paid. The other is that it would have been futile at the time. So, exhaustion can be excused if it's futile. Here, OPM guidance was against him. The consistent practice of the agency was against him, and the person he asked at the agency told him he wouldn't get it. So that was why he didn't make the request.
Do I remember correctly that what he did during the time when he was called up was to serve as the captain of a Coast Guard vessel that was escorting military vessels in and out of harbor?
Yes, I don't know that. I don't think he was the captain, but he was a petty officer.
He was a petty officer on that. Why wouldn't that meet even the Adams standard?
I actually think it does meet the Adams standard. This case, for various reasons, the court ruled against us and said there was no evidence he was directly serving in a contingency operation. Adams hadn't been decided when the record closed in this case, so we didn't develop those arguments. And the way this was presented to the Federal Circuit was, you should overrule Adams. He's just entitled to the differential pay, and that's how it was litigated below.
At what point do you think the veterans canon, if it is a proper canon of interpretation, should come into play in this case? Would it come into play only if we thought that the arguments were in equipoise?
I have a strong view of the veterans canon. I think that it is something that's sort of more powerful than that. I think that it is a evidence of how Congress thinks about how veterans should be treated based on their service to the country. But certainly, if you get to equipoise, it should be a thumb on the scale in our favor.
The canon is based on the thought that Congress wants any ambiguity that it leaves in the statute that could provide a benefit for veterans under all circumstances, no matter the cost, to be resolved in favor of the veteran. That is a guess about the way Congress thinks.
I think you might even elevate it to the level of like a structural constitutional principle. I mean, just as the court has the federalism clear statement canon, I think, when it comes to veterans and service members, since the very first Congress, there has been an effort to ensure that those who put their lives on the line for us receive compensation.
It's constitutionally based? On what provision of the Constitution is it based?
Well, I think it's based on the structure of the Constitution, I guess, is the point.
What is it about the structure of the Constitution that supports it?
Well, there's the fact that most of Article 1, Section 8 is devoted to military provisions. I don't think that we have to get into high theory of the veterans canon, but it is, if you look at the original Constitution, it's primarily a war machine. It's designed to ensure that the country can remain one going forward. And a crucial part of that is ensuring that veterans and reservists receive the benefits of their...
Thank you.
Point of clarification, the orders here were a call-up for a military contingency, so assuming that your responses to Justice Alito why your failure to act earlier should have been excused, one of his call-ups were for a medical treatment. Under your theory, that plus, I think, regular service, the 2 weeks that reservists have to train, all of that would be paid the differential pay, correct?
Your Honor, his injuries were in the line of duty, and then he was called under 12301H to convalesce. But, you know, he was injured for while doing the contingency operation, and or yes, he would receive differential pay for that.
And so would he for every reservice for the 2 weeks of service they render in just basic training.
I think that there may be arguments about whether that constitutes a call to active duty under a provision of law, but assuming that it is, yeah, you would receive the pay, just as you would receive your ordinary pay.
Justice Kagan? Justice Gorsuch?
You haven't mentioned your argument about the unexpected criminal liability that employers might face, and I just wanted to give you an opportunity to offer that in light of the government's response in its reply brief.
Thank you, Your Honor. Yes. So obviously, Section 209H is a carve-out to a criminal prohibition that says that if you pay differential pay under the exact same terms as this statute, so they have the exact same words, that you are exempt from this criminal statute. So private employers, relying on that language for decades, have been paying those who are activated who work for them differential pay. And the implications of this case are that there are differential pay policies. We did not identify them for obvious reasons that do not match the government's vision of what this statute says. And so they would be out of compliance and have been out of compliance with what the government's version of the scope of this provision is. And so relatively large companies would be retroactively potentially criminally liable as a result of a ruling against us in this case.
A quick question. The Adams opinion suggested that somebody called up had to be directly involved in a contingency operation. I don't see either side defending that rule. So should we just vacate and remand on that basis? What would be wrong with that?
We welcome the government's decision to sort of abandon the Adams rule, and we do think that no matter what happens, the court would have to vacate. But we think that we're here to get the statute right. We think that Congress enacted a bright line rule that wasn't designed to create a bunch of line drawing problems, and we would be down in the federal circuit litigating forever.
No, I understand that, but normally we don't decide issues in the first instance, and here both sides have presented a raft of arguments that no lower court has passed upon, and normally we wait for circuit splits. Here, of course, we can't get that, but we could at least get the federal circuit's considered judgment on your theory and the government's present theory, having rejected the one that nobody seems to be willing to defend.
Your Honor, it would be kind of a boon to the government for having kind of moved their position, right?
Hey,
they have procured.
You don't win everything, but, you know, it's better than a loss, isn't it, counsel?
Yes, Your Honor. Yes, and we would, of course, accept a vacate and remand if the court is of the mind that this should be passed on by the federal circuit first.
Justice Kavanaugh?
On the criminal liability point, obviously there would be a good mens rea defense, so just point that out, right? At least for those, you know.
Yes, but again,
it doesn't defeat your point. I'm just saying retroactive, unknowing liability is something would be doubly frowned upon.
Yes, so if the court is ruling against us, you should say that absolutely. I think that would be a welcome thing. But I would say it is going to be, under the government's theory, very difficult for employers to figure out whether or not their differential pay policies are compliant. The government says just look at their orders, but the orders are written by members of the person's unit. They're written by...
Well, the government then adds that, I think this goes to your line drawing point too in your opening, that if in a particular instance a service member's orders are not clear, he or she can seek to have the orders clarified.
And then I guess we would be litigating the very argument that the government has declined to make, which is whether the person's service is going to be sufficiently connected in substance. And again, that gets you to backfilling security operations, that gets you to training to go be deployed, that gets you to all of the line drawing problems.
Thank you.
Thank you, Your Honor.
Justice Barrett? Justice Jackson?
Can I just clarify? I'm sorry. So the orders cite to a particular contingency, or they don't?
They sometimes do and they sometimes don't. They are supposed to, I think. I think the government will come up and say that they are supposed to. It is They usually just say what provision of law you're being called up under.
And if they're silent on that, and we were to hold that a substantial connection is required, what's your view on the process then?
So my understanding is that the government is saying that orders will then be consistently written in a manner that ensures that a reservist knows whether they are going to get differential pay by looking at the face of their orders, and if it doesn't say, and the reservist
And if that
thinks it
happens,
will.
does that defeat your argument about administrability?
It does if you think that this will be consistently carried out and that it complies with the statute. The big problem for the government's position is obviously that it doesn't really match up with the statute. There's nothing in the statute's use of during that implies that there's going to
No,
be.
I understand your point.
But
Thank you.
Yeah, thank you, Your Honor.
Thank you, counsel.
Thank you.
Ms. Reeves?
Mr. Chief Justice, and may it please the court. The word during has multiple meanings, and as with many words, the meaning of during in any particular sentence will depend on context. I want to highlight 3 pieces of context that make clear that during a national emergency means in the course of a national emergency, not at the same time as one. First, the phrase during a national emergency is part of a broadly applicable definition of contingency operation. Petitioner's reading fails to account for the fact that the term generally connotes an operation taken in response to a particular contingency. And national emergencies are often declared for non-military purposes. One that Justice Kavanaugh referred to, for example, is called blocking Iranian government property. It's a prerequisite for certain economic sanctions, and it's been in effect for over 45 years. As a matter of plain language, we would not think that voluntary active duty training falls under the umbrella of a contingency operation, so long as there is a declared economic emergency. Second, reading during to merely require temporal overlap would make most of Section 101A13B unnecessary. Because multiple national emergencies are ongoing at all times, petitioner's reading renders the list of expressly cross-referenced provisions and Congress's multiple additions to that list entirely superfluous. And the court has applied superfluity in cases like this, where superfluity is a result of language in the statute and practical effects of the way the world works. I'd point the court to TWA v. Andrews as an example of that. And third and finally, petitioner's reading would result in a number of anomalies, including requiring differential pay for reservists who have been court-martialed and incarcerated. For those and other reasons, the context makes clear that during does not carry a wholly temporal meaning here. Petitioner has consistently failed to seriously engage with the text and context, and neither DOD nor the Coast Guard nor any court has ever adopted petitioner's reading of during in the definition of contingency operation. This court should not be the first to do so. I welcome the court's questions.
Has your position been adopted before by MSPB or by the Fed Circuit?
So it has not been adopted by the Federal Circuit. Our position has been adopted by the Federal Circuit. I think the Federal Circuit's position is probably a bit narrower than our position. So we are providing a more benefits-friendly approach. And as far as the MSPB goes, the MSPB as a whole has never issued a precedential decision on this. There's a 2016 decision called Marquise, where the board as a whole divided on this question. ALJs have come out different ways. So petitioner in his cert stage papers cited some examples of individual ALJ judges coming out his direction. We looked and there are examples of individual ALJs coming out our direction as well.
So there's some degree of novelty to your reading also then?
I don't think there's novelty. I think there has been articulations along the lines of what we said by individual ALJ judges. But I think at the end of the day, the kind of main point is that this reading of wholly temporal meaning of during that petitioner has laid out is a really unique reading that other than a handful of ALJs just hasn't been adopted anywhere.
Do you think
How do you respond to the petitioner's point that your reading would expose private employers to more criminal liability?
So I have 4 quick responses on that. The first is that our reading is no narrower than the Adams decision. I think it is broader. So assuming companies have been following the prevailing law, I think we're not creating any retroactive liability. Second, the DC Circuit has held that there's an intent requirement. It's a decision called U.S. versus Government Accountability. I think that would definitely cover the mistaken employer. And third, I don't think this is a situation in which we get into lenity. First of all, because I don't think there's the sort of grievous ambiguity that would lead to lenity itself. But my fourth point is I think it would be an expansion of the lenity doctrine to apply it to a general definitional statute. The court has applied lenity when a statutory prohibition has both civil and criminal penalties, and it's applied it in civil cases for that reason.
Ms. Reeves, I'm sorry, Chief.
We've had a lot of discussion about what Congress meant, and rightly so. If you were someone sitting down trying to decide whether to sign up to be a reservist, and you read this provision saying you get the same pay, if you're called up during a war or during a national emergency, and you find out there are 43 or however many it is national emergencies, and that extra pay is very important to me. How do you think a normal person would read that language?
I do think the best reading that kind of anyone would have of this language is if you look at all these expressly cross-referenced provisions, and then you look at during a war or during a national emergency, it wouldn't make sense to read that so broadly as to swallow up those other provisions. And I think a reservist wouldn't necessarily think that, oh, if I volunteer for JAG training, that means I'm serving during a national emergency. I don't think that's sort of the way an ordinary person would think of this.
Well, you started, I think the first thing you said was, well, if you look at all the cross-reference provisions, I don't necessarily think somebody trying to decide whether to sign up would do that. I mean, just looking at the language during a war or during a national emergency, it seems to have a pretty strong temporal aspect.
I disagree, and I think, again, I would point the court back to the fact that this is part of the definition of contingency operation, and it applies over 40 places in Title X and over 20 places outside of Title X. And when we think of a contingency operation, we don't normally think of something like volunteering for training. We think of something like a unexpected mission in response to a contingency. So I think, if someone read the whole statute and the whole statutory provision, I don't think they would think that this just has a temporal requirement.
Well, and you say it doesn't mean during doesn't have a temporal limitation. It also means in the course of. I got to say I must be missing something, because I would have thought in the course of means pretty much the same thing as during. If during has a temporal limitation, I don't see how in the course of wouldn't.
So I think in the course of does have a temporal limitation. It just also requires a substantive connection. And I think the plain meaning examples we provide in our brief, someone arguing during a hearing, an obligation to be truthful during an application process, disclosures permitted during or anticipation of a litigation, all of those are requiring both temporal overlap, of course, but also a substantive connection. And that's a very common use of the term during. And I think once you kind of get past that point, the context just makes clear that a substantive connection is required here.
Well, I'm not sure I agree with you that it's a common, to the extent you're saying it's different than in the course of, I'm not sure I understand how it's a very common meaning. I think, will you give me at least the most common reading? Is it means at the same time as?
I'm not sure it's the most common reading, but I think even if you think it's the most common reading is wholly temporal, that doesn't excuse the court from having to go through this context sort of analysis. So take the word cool, for example. It means both cold temperature-wise and calm and collected. I think certainly cold temperature-wise is the most common meaning of that term, but that doesn't mean someone reading a sentence puts the thumb on the scale in that favor.
It could mean a lot of things. It could also mean, hip. But I mean, it's not the same kind of word as during.
I think it is a similar word to during in that it's a word that has multiple meanings. And when a word has multiple mainline meanings, the court doesn't kind of put a thumb on the scale. It looks at the word in context and tries to sort out what it means and what Congress meant by adopting that word in this context.
Ms. Reeves, in response to Justice Thomas's question about the criminal liability under Section 209, I take the mens rea point on past liability, but I think your friend on the other side had a stronger point that I didn't hear you address, and that is private employers will have no way ex ante to know whether they're violating a federal felony, committing a federal felony, because they don't have access to orders all the time. The orders don't contain the information that are necessary to determine whether they should be providing differential pay or whether they're forbidden from doing so. If During has this substantive connection, how is a private employer to figure out whether this fellow with these orders is engaged in conduct during a national emergency? Temporally, he can figure that out. Very difficult to figure out if there's a substantive component that's undefined.
So a couple of responses on that, Justice Gorsuch. So first of all, I do think actually it will be fairly straightforward for both agencies and private employers to sort out who's entitled to differential pay. And I do think that that is because the call or order to duty, and we cite Army and Navy and Coast Guard guidance explaining that the call or order to duty is supposed to state the contingency operation, whether it's in support of one, the statutory authority for it, and the basis for the call-up, whether there's an executive order. Now, petitioner has provided no evidence for his assertion that that commonly does not happen.
What do you think? Do you know? Does that commonly happen? You cite regulations, great, but you also want us to take cognizance of the real world and how many national emergencies there are. So perhaps we should ask you, how common is it for the orders not to contain the information that's required to know the answer?
So DOD has informed me that it is rare, that this guidance is commonplace, and that the orders normally contain this sort of language. And as we explained, the way for an individual, whether they're employed by a federal agency or whether they're employed by a private employer, if their orders don't say that, they follow that OPM guidance, they go ask for clarification on the orders from the Army or Navy or whoever they're employed by. And when those are corrected, it is in fact clear whether or not they're entitled to differential
It's just
pay.
that a well-meaning private employer could find himself to be a federal felon for actually trying to pay money to somebody.
I don't think so because of the mens rea requirement.
I understand.
Could I ask you?
Now, just one last thing. You've acknowledged that this During argument is different than the Adams precedent, and it is. And Justice Thomas also asked you, would it make sense to at least get lower courts to pass on this before we do? We're never going to have a circuit split, but would it be prudent to at least have the benefit of some lower court thinking on what is presented to us for the first time in this court, a new theory?
I think 2 points on that, Justice Gorsuch. First of all, we don't have a problem with sending this case back. We obviously opposed certiorari in this case. I think the second point I would point out is that in our brief in opposition in Adams, we made essentially the argument we're making to the court now. And we did, in fact, make that to the Federal Circuit in opposition to petitioner's cert petition in this case, and I believe some on the merits of this case.
That's interesting that even despite the government's concession that they're wrong, they haven't yet fixed their precedent. So I wonder whether that augurs for doing just that, clarifying that that's wrong.
Again, I mean, I think we oppose cert because we think this broad argument that no court has accepted is wrong.
You have no objection to this, to vacating and remanding because Adams is wrong.
So I think we would have an opposition to vacating here for a couple of reasons. Because petitioner this whole way through has presented only one argument, and my friend on the other side. No, my friend, so I think it's important to keep in mind what is wrong in Adams here. What is right in Adams is its rejection of petitioner's argument that mere temporal overlap entitles someone to differential pay. That is the only argument petitioner has presented throughout this case. He solely took this up to broadly challenge that broad argument in Adams. And so I think a vacater in this case would be inappropriate because that would essentially be giving petitioner a benefit for making a broad argument that this court was unwilling to affirm on.
It's just odd that he would lose even if we all agree Adams is wrong.
I don't think that's right. I think some of the dicta in Adams we aren't embracing here, and we've never embraced. We didn't embrace it in our brief in opposition in Adams. We didn't embrace it in our brief in opposition here. But the mainline holding he's challenging, we do think is wrong.
Thank you.
I have two lines of questions following up on this. You show the FAA policy to me, but that has no time limit as to when the request for differential pay could be made. So if it has no time limit, why is their failure to have asked for it earlier fatal?
So it's not a timing problem here, and the FAA will consider if the court affirms in this case and petitioner actually files a request for differential pay, FAA will consider that under the standard laid out in our brief, and we anticipate he will receive differential pay for the 3 periods at issue in this case.
So let me stop and go back to, he was fighting the Adams decision before the board, which basically made the orders irrelevant. It required him to prove that his work had a substantive connection. You admit that that requirement was not necessary, but why should he be faulted for failing to anticipate a position that the agency rejected?
So I don't think that the argument that his orders are in support of a contingency operation or in the course of a contingency operation was in any way foreclosed by Adams. The only thing Adams squarely rejected was that solely temporal overlap alone was not enough.
That's not how I read the Federal Circuit's Adams decision. I read it as saying, even if your order specified that it was for the Iraqi fight, that you had to prove that the actual job you did related to that contingency operation.
I think maybe there's some loose language in Adams along that lines, but I wouldn't say it's relevant to the holding of Adams because the facts of Adams.
We're going to fight about a reading. I think it's fairly clear to me, both in Adams and in this case, that they faulted him for not proving the substantive connection between his work and the Iraqi operation.
I do think it's important to keep in mind, though, the facts in Adams, his orders said he was called up in support of a non-contingency operation.
Adams was very different, I agree. Now, there is one other area that I want to cut, and I noticed before the Federal Circuit, you argued that the enumerated provisions in 10 U.S.C. 101A 13B should inform the court's understanding of the final clause we're interpreting here. You seem to be making that argument at the bench before us earlier, but in your briefing you gave it up. But if I look at those cross-references, all of the enumerated contingency operations are, some of them require a connection, substantive connection, some don't. So what's your position? Either all of them require a substantive connection, or they don't. And if they don't, why do we use them to inform us about whether this requires a substantive connection or not?
So we haven't made the argument here that, before this court, that all of those cross-reference provisions require a substantive connection. The argument that I was making and that we did make in our brief is that the court should consider the fact that it's defining contingency operation and the plain meaning of that term.
That seems like having your cake and eating it too.
You
want to say in this one provision, it requires a substantive connection, but it doesn't in all those others. It might not in all those others. And the reason it might not in all those others is because all those others don't mention that connection.
I don't think that's right. And again, we haven't made that argument for a reason, but I think if you're trying to make a little sense of how Congress might have been thinking and what it wanted to accomplish by writing things this way, all the expressly cross-reference provisions provide a basis for involuntary calls to service. And I think it would be rational for Congress to say, well, we want all involuntary service calls of any type to entitle individuals to differential pay. And volunteering for service in the course of a national emergency should entitle them to differential pay. But volunteering for active duty training to go to JAG school or something like that does not automatically entitle someone to differential pay. I do think that's kind of a logical way to draw things.
So 10 U.S.C. 1230.02 that provides that in time of national emergency to activate a unit of the Ready Reserve without their consent. Does that require there to be a national emergency related to a national emergency?
No, I don't believe so.
All right, so you are inconsistent there. Okay.
No, I don't think we're being inconsistent.
I know you're saying you're not, but I don't see how I can get to substantive if you say that Congress intended there to be a substantive connection here,
But only as to the other provisions of law that weren't expressly enumerated. Congress obviously made different policy judgments as to all involuntary call-ups that are covered under those other provisions.
Can I ask about the CBO scoring? Because the CBO scoring really does seem to assume the petitioner's position here, and I'm wondering how you think that came to be, or how we should think about the relevance of that.
So I have 3 points on that, Justice Kagan. First, the language originated in CBO reports that were analyzing the materially different statutory proposals that suggested that all active duty service would be covered. And second, when that statutory text changed, the CBO reports didn't analyze that. They just carried over the analysis from those prior reports.
So my understanding of the way CBO usually works, and you tell me if you think it's different in this situation, but that there's, a back and forth and maybe a continuing dialogue, really, between CBO staffers and legislators, because it's in everybody's interest that the scoring actually reflect the nature of the thing that Congress wants to do. So I guess I would be surprised if you were to tell me there was an initial thing that they based this assumption on, and then everybody just stopped talking to each other.
Well, I think one thing to look at is that these reports were very quick succession, and that change occurred, and I believe the next report came out within a matter of 1 or 2 months. So I'm not sure that there was sort of the time and analysis that one might expect for that changed kind of statutory text.
Well,
but the third point I wanted to make...
Sorry to interrupt, but Justice Kagan suggested that all sides have an interest in making sure the score is accurate. I wonder whether there's actually an incentive to make sure the score is as low as possible, and that if there was a change during the drafting process that was material and people thought it would reduce the score, they would have had every incentive to note that.
I really can't speculate on what this particular CBO office or the senators and representatives that were speaking to them were thinking about. But the third point I want to make, and I think this is very important, is that even under petitioner's reading, those later CBO reports got it wrong. So one of the other changes that happened was referencing the definition of active duty service in Section 101D. And that excludes full-time National Guard duty. And if you look at those CBO reports, they all say that full-time National Guard duty will be covered. And I don't think petitioner would dispute that, but it's yet another way. So, if you go with petitioner's reading, the CBO reports got one big thing wrong. If you go with our reading, it got 2 big things wrong. I just don't think this is a situation in which the CBO reports should play any sort of major influence in overriding the best meaning of the congressional text.
The overall amount of money at issue here is roughly?
Unfortunately, I don't have any numbers on that because each civilian employing agency is responsible for paying differential pay. We don't have consolidated data on that.
I guess my point, it's not a huge number in the grand scheme of the federal budget, correct?
I think that that's probably fair, but that doesn't...
You don't know?
I don't know.
I think you said something earlier that's important, just to make sure I have it right. Even if we affirm, petitioner could present the orders or go back to the FAA and make the request, and would likely, I think you said, I don't want to put words in your mouth, get the differential pay for the pay periods in question, correct?
That's correct. The FAA, if he submits his earning and leave statements, which again he's never done, it's at PEDAP 32A, and his orders to the FAA, they'll adjudicate it under the standard laid out in our brief.
So even affirming, absent something unexpected, he's going to get his pay?
That's correct, yes.
Okay. Let's see. Footnote 4, you say you're going to change the OPM, or not you, OPM's going to change its guidance going forward. Can you just clarify what you mean by that?
Yes.
I think you've already explained it, but I just want to nail it down in connection with footnote 4.
Of course. So I think if the court were to affirm here and just reject petitioner's argument, OPM would update its guidance to be in line with the standards we've laid out in our brief. So to instruct agencies to look at the text of the orders. If there's confusion about that, to go back to the Navy or Army or Coast Guard and request clarification from them. The guidance will, of course, make clear that this final clause in Section 108A13B, is going to be based on the text of those orders. And so I think it will be very clear from that guidance, the rule that agencies should apply when adjudicating differential pay requests.
What about last one?
I'm sorry, go ahead.
I'm good.
Well, if it's your last one.
Pressure. Can you explain, and I think you've touched on this, but explain how adopting petitioner's interpretation would cause ripple effect problems in other areas of the law? Because I want to make sure I understand how the interlocking pieces work here.
So I think our real point is that the term contingency operation is used in numerous places throughout the U.S. Code, over 50 times in Title 10, over 20 times outside of Title 10, either contingency operation or one of the provisions within that definition are referenced. And our real argument here is that it wouldn't make any sense to use petitioner's definition of deering in all of those sorts of contexts. So I think we've pointed out some of them on our brief on pages 5 and 22. And a lot of these fall into the categories of exceptions to various obligations, such as spending limits and use of certain resources and requirements to notify Congress. I think if you accepted petitioner's reading, then it would suggest that these requirements have very little teeth, because they would essentially be excused as long as a national emergency happens to be ongoing at the same period of time.
I understood your discussion with Justice Kavanaugh. You said that the petitioner here would be entitled to get the relief he's seeking. How?
So he would need to, again, because petitioner has never actually submitted his earnings and leave statements, there's no way for the FAA to calculate any differential pay to which he's entitled. It's not as if every civilian agency has access to DoD pay stubs. They're separate pay systems, and they can't acquire it. So there's—
so you're just talking about him in this particular case?
Yes,
due
I
to
was
that
just talking about
particular nuance. I thought it was you were offering broader relief than that.
No, I was just talking about petitioner.
I understand the oddity of having all these statutes enumerated if petitioner's position is right as to the catch-all. But you don't think that it's odd to have the policy that petitioner is suggesting, do you?
No, I don't think our argument is ultimately a policy argument at all. I think it's based on the text and context here.
Well, I mean, I guess what I'm suggesting is it would make perfect sense for Congress to say something like anybody who's caught up in these perilous times ought to get a pay differential because everybody contributes in their own way. So regardless, as if you're at the front fighting for a war, or you're the military recruiter, or you're anything else, you know, that everybody contributes to the effort that is needed in these emergency times. That would make perfect sense for Congress to think, wouldn't it?
Yes, I think it would make sense. I just want to point out that I think petitioner's argument actually goes broader than that, because he's arguing that individuals who volunteer for training are also entitled to differential pay. And I don't think those sort of individuals would kind of fall within that logic.
I don't really know why. Like, we need people who get training so that they can step up, you know, when their turn comes.
Maybe that would apply for involuntary training, but I'm less sure if it would apply to voluntary training. But I don't want to fight you that Congress could have made a very different policy choice here, but the easy way to do so would have just been to say all active duty service and adopt one of the other provisions it considered before adopting this cross-reference to contingency operation.
Ms. Reeves, can you address the state's amicus brief where they say that you're pegging this to the orders rather than the statutory authorization when the statute doesn't say that it depends on the way that DoD writes the orders?
So I actually think the orders language is in the statutory text, both in 5538 and 101A13B. So obviously, if you start with 5538, it's someone who's performing active duty in the uniformed services pursuant to a call or order to active duty. And then it goes through the statutory bases for that. And then similarly, in 101A13B, it's again results in the call or order to or retention on active duty of members. I think another way to think about this is to try to insert it into the question presented. So I don't think the question presented makes sense if you ask whether a call or order to duty is at the same time as or in the course of a war or national emergency. I don't think it makes sense is if you ask whether a provision of law is at the same time as or in the course of a national emergency.
Do orders change in the midst of service?
So an individual might receive a different set of orders. So I think what usually happens is the orders is for a particular period of time. And then they might, when the orders are set to expire, they might decide to volunteer for more duty, in which the orders would be changed, say if their initial duty was involuntary. Or the agency, or DoD might decide to continue them on involuntary service. But at the end of the day, you know, the basis for orders are first, the statutory authority that DOD has and the facts of a particular mission.
But does DOD switch them? I guess what I'm getting at is even if they started out doing something that doesn't fit your conception of a connection to the national emergency, does DOD switch what they're doing midstream? And then how is the agency supposed to know, or a private employer supposed to know, oh, now actually they've shifted and they're doing something more closely connected?
So yes, in that sort of situation, if someone was not working in support of a contingency operation and then that changed, DOD would write them a new set of orders, and then the individual would, just as with any other differential pay request, need to submit those orders and his leave and earning statements to his agency.
And that invariably happens?
That's my understanding, that that is what is required to happen. You know, the reason we caged this a little bit in our brief is because occasionally mistakes do happen. And, you know, DOD does not execute all orders with perfection. But again, petitioner hasn't identified any situations, let alone any broad issues with orders being miswritten. And we do have this option for individuals to seek clarification if there is a mistake. And I think that the guidance would obviously apply if there's a change in orders, such as you've articulated.
There are going to be difficult line drawing problems under your approach, isn't it? I mean, let's say you're dealing with an air traffic controller, and it's not involving, in the course of, just doesn't do it for me, but it's not involving a particular emergency at that time. But in the back of the Army or Air Force's mind is, you know, we want to have a trained cadre of reservists who are used to dealing with the military operations and air traffic controlling. And as long as he's here or she's there, it'll help us to have that background. I mean, would that be in the course of whatever national emergency would be invoked later on?
I think it would depend on how DOD chose to write the orders in that situation. You know, again, DOD can't call someone out without a statutory basis for that, and it has to abide by limits that Congress has placed on it. And DOD isn't writing these orders, you know, focused on what the differential pay effects is going to be. It's focused on the needs that it has, whether that's training needs, whether that's service needs. And so DOD writes the orders accordingly, and they are going to say whether or not it's a contingency operation and whether or not it's in support of an executive order that's involved in a national emergency. So I think it is going to be clear generally whether someone's entitled to differential pay.
Thank you. Justice Thomas? Justice Sotomayor?
Can I just ask, having the differential pay scenario turn on the order, that doesn't seem so odd to me, but can you just speak to that? I mean, it seems like what the statute contemplated, right? I mean, in response to the Chief Justice's question, you have to look at what the person is being called up relative to, and if the order says that, is it the government's position that that's all that's necessary?
That is, and I think you're completely right that there is a textual hook for that, both in Section 5538 and in Section 101813B. Both refer to the call or order to active duty, and I do think that that really gives us a textual basis for
Was that the
looking at
government's
orders.
position before on this? In other words, I'm wondering whether the OPM scoring debacle could be related to a lack of clarity as to how we would figure out, you know, substantive connection without this kind of clear guidance.
I'm genuinely not sure what OPM was thinking about.
Yeah.
You know, I can't say that in the legislative history that I've looked at for Section 5538, there was discussion or that much focus on the orders, but obviously the relevant legislative history, if this court were to look at it, which we don't think it should, is Section 101A13B.
Thank you.
Rebuttal, Mr. Tutt?
Thank you, Mr. Chief Justice. First, I want to say that the government has abandoned the Adams rule. The Adams rule couldn't be clearer. It was applied twice in this case. It says you have to be directly called into a contingency operation in order to receive differential pay. Our client was not called directly into a contingency operation. His orders say he was in support of a contingency operation, so he was not eligible for differential pay under Adams. So the government's concession finally came at the 11th hour at the merit stage in this court. So if you are inclined to rule against us, you should at least vacate and allow the Federal Circuit to get it right. But we think that the correct reading of this statute is clear. Mr. Chief Justice, you understand our reading absolutely. If an ordinary person read this statute, they would think, I get differential pay as long as I'm called to active duty under a provision of law during a national emergency. There are 43 national emergencies. I get differential pay. Most of them are looking at one national emergency, one extremely important national emergency, the 9/11 emergency that continues to this day, that has been the basis for so many deployments overseas, that triggered calls to active duty minutes after the planes struck the towers on September 11th. And individuals were not just called to go serve in Afghanistan and Iraq. They were called to protect airports. They were called to fill in numerous security functions to ensure that there was not a repeat of the attacks shortly after they happened. I want to talk about ripple effects because I feel like it is a real sticking point. The government admits that the enumerated provisions don't require a substantive connection between the emergency and the service. So in other words, like my client, you could be called up under 12302 orders. He was called to protect the Port of Charleston under 12302 orders. Under the government is claiming that that made protecting the Port of Charleston a contingency operation. Obviously, they don't treat it that way. It is not going to have these ripple effects because lots of people, almost all throughout the military services, individuals are called to active duty under enumerated provisions, not related to a pending national emergency. They're not transforming everything the military does into contingency operations. So this ripple effect idea is something that's in the air, but it doesn't have practical effects with how the government is actually treating contingency operations on the ground. I also want to point out, I looked at all of the contingency operation statutes, and the parade of horribles is not actually that horrible. It mostly pertains to benefits for individuals, and it pertains to procedures that agencies have to follow, and then a few extra additional powers that the agencies have that they typically have with respect to responding to important national events. I want to talk about the adjus dum generis argument because I think that it reveals the hollowness of the government's position. The government contended in Adams that all of the call-ups have some relationship to the national emergency. They've given that up because they do not, and that so they can't inform the scope of the catch-all provision. So, and to Justice Jackson's point, Justice Jackson pointed out that you think that it's very simple. You just look at the order, you look at the provision of law under which the person is called. But if you look at the provision of law that a person is called under, like 12301D orders, our reading is that if it's during a national emergency, that means you get differential pay. The government is saying you have to have something additional in that order. You have to have some reference to the national emergency. And that reference to the national emergency is not something that they have to put in. They're supposed to say whether your service is connected to a contingency operation under their regulations. Again, these orders are written by junior enlisted people. They're not issued by the Pentagon. They do not typically change while a person is serving. So, in other words, if you are stationed somewhere and it suddenly becomes a combat zone, you are apparently not going to get differential pay. And I want to say that people are called to respond to national emergencies all the time. 9/11 was a good example, that are not military or fundamentally military in nature, but they should still get differential pay because they're serving on active duty, sometimes under enumerated provisions. So for instance, responding to the COVID-19 emergency, reservists were activated to respond to that emergency. It's not a fundamentally military emergency. So again, I don't think that the government takes the position that it was a contingency operation. So the idea that this creates sweeping sort of ripple effects throughout the United States Code, or that our reading is so implausible, I don't agree with. And I just want to close by saying that it obviously is good policy. It obviously is defensible policy. No one at any point in the enactment of this statute presented it as anything other than applying to all reservists. We urge you to reverse. Thank you, Mr. Chief Justice.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.